Supplementary list old matter item number 1.
The matter become infructuous to disposed of. Correct.
Supplementary list item number 2.
None appears dismissed. No.
Supplementary list item number 3.
None appears dismissed. No.
Supplementary list item number 4.
None appears dismissed. No. 4. Not pressed. All right. Infructuous and therefore not pressed. Right.
Supplementary list item number 5.
None appears dismissed. No.
Supplementary list item number 6.
I am the opposite part number 5.
All right. None appears the appellate dismissed for non-prosecution.
Mr. B. Das, Board of Secondary Education Odisha, Mr. B. Das, appearing for opposite number 5.
All right, sir.
And
Supplementary list item number 7.
None appears dismissed. No prosecution.
Item number 8.
None appears dismissed. No prosecution.
Supplementary list item number 9.
None appears dismissed. No prosecution.
Item number 10.
None appears dismissed. No prosecution.
Item number 11.
Same order.
Item number 12.
Same order.
Supplementary list item number 13.
Same order.
Item number 14.
Same order.
Supplementary list item number 15.
None appears dismissed. No prosecution.
Supplementary item number 16.
both the respondent.
My lord, I am for the appellant. The appellant has already taken the consent along with the file from me.
All
And
right.
there is no
Counsel,
further
the appellant states that the file has already been taken from him. None appears for the. There's no alternative arrangement. None appears for the appellant. Dismissed or not prosecution.
Supplementary list item number 17.
None appears dismissed. No prosecution.
Supplementary list item 18.
18 my lord, pass over.
All right.
Supplementary list item number 19.
None appears dismissed or not prosecution.
Item number 20.
None appears dismissed or not prosecution.
Item 21 already mentioned. Supplementary list item 22.
None appears dismissed or not prosecution.
Item number 23.
My lord, it is a PIL matter, my lord, regarding Sishu Bhavan. And the affidavit as mentioned in the first list, the copy has not been served on me.
No notice is gone in this matter. Acha, notice. No, which is this? Which petition are you arguing, sir?
This issue 9504 of 2015.
Oh, what is called out is 2722733.
For 23 item is
I see.
9504.
I see.
23 is mentioning.
Acha. There's already another matter on Sishu Bhavan, no? That might be.
Yes, that is another matter.
Ah.
The number.
That has been filed later on, so this may be tagged, man.
Yes.
All right, list along with that other Sishu Bhavan matter on the same day.
5th September. Supplementary list item 24.
None appears just an opposition.
I am appealing for respondent.
All right.
Supplementary list item number 25.
Lordship, item 25 has become infructuous.
All right. Dismissed as infructuous. All right.
Supplementary list item 26.
None appears dismissal on opposition.
Supplementary list item 27.
None appears dismissal on opposition.
Item number 28.
May I please, Your Lordship? This is a matter regarding illegal construction of a fish market over the water channel, which is reserved under government khata for the purpose of water channel. The construction is made by the Nimapada municipality without obtaining the permission from the government and on the basis of a no objection certificate given by the Tahsildar Nimapada. This without following the procedure of law under the Odisha Government Land Settlement Act. The Odisha Government Land Settlement Act provides how a land is to be de-reserved and it is to be reserved. Provides. Without following the principle, they have done it. Now the Lordship passed an interim order not to make any third party interest over the land by giving the land to the fishermen of the locality.
Or
And-
you give an advance notice, Mr. Manti, no
Yes.
counter affidavit has been filed for 6 years now. Status quo has continued. Stay has been there.
Yes,
So we'll say that will continue now.
yes,
If you want to construct a fish market, you follow the procedure in accordance with law.
yes. Nimapada NSC, I think.
Nimapada NSC, but they have to obtain the permission from the government.
NSC is the opposite party because we
Yeah.
cannot appear for them.
All right. You see, this is a writ petition filed in the nature of a public interest litigation, praying inter alia for a direction to the to quash or inter alia to quash the order dated 6th April 2016 issued by the Housing and Urban Development Department, Government of Orissa, rejecting the representation of the petitioners against the construction of a fish market by the Nimapada Notified Area Council (NAC) over governed Sabik plot number 2897 in Moza, Andhya, over an area of AC 0.55 decimal of Kisam Jora land (water channel) pertaining to Sabik Khata number 635. Paragraph. While directing notice to issue in the present petition on 26th April 2016, this court passed the following interim order on the same date. Reproduce the order in the missed case. Paragraph. More than 6 years have elapsed since the passing of the above interim order, and yet no reply has been filed by any of the opposite parties till date. Stop. In other words, the interim order has continued for well over 6 years. In the circumstances, it is directed that if the opposite parties desire, while making the interim order absolute, it is directed that if the opposite parties in future desire to revive the proposal for constructing any fish market, then advance intimation will be given. Sufficient public notice will be given regarding such proposal. And after hearing the objections to such proposal,
Under the Government Land Settlement Act, because the land is of the government, NSC cannot make
whatever
any
in accordance with law, and proceed only thereafter, and thereafter proceed only in accordance with law. The petition is disposed of at the bottoms.
You also may indicate government land, otherwise they will not follow.
That's all right. So if they don't follow, you're very happy, then you'll come back with another writ petition. All right.
Supplementary list item 29.
Pattern to mention, I may interrupt, Lordship. Item 12 and 13.
Sir, we have already caused that, sir. You'll have to come back.
Sorry, my lord.
We are sorry, sir. You just have to wait.
12, 13, that means no instruction is there, no Lordship dispose of. 12 and 13.
All right.
Item number 29.
None appears disposal of prosecution.
Item number 30.
None appears disposal of prosecution.
Supplementary list item 31.
Item 31, my lord, this is a PIL matter This is a public pond covering of acre 1.777 decimal, which was illegally acquired by OP numbers 4 to 6.
Same thing, this interim order is continued now for 5 years.
Plus, may be permitted to file a counter affidavit in this case.
Not now, sir, not so late. 5 years are over already.
One chance may be given, boss.
Dumping waste, sir, might as well stop dumping waste. So let that interim order be made absolute.
No, I'll take instruction. This matter may laws will help later, next week or some other day.
Mr. Katkia states that he needs time for instructions. The interim order to continue. List on 2nd November.
Supplementary list item 32.
None appears dismissal or opposition.
Item number 33.
May I please, Your Lordship?
Plugger.
My Lord, the Titlagad Bar Association is the petitioner before Lordship. Their grievance is that some partnered matters has been transferred.
All this not a PIL. This is not a PIL.
My Lord, in
these are not matters for PIL, sir. Sorry.
My Lord, the Bar Association had, in fact, the under Annexure 3 made a representation to the chief.
You are already on the administrative side, same issues there. Also on the judicial side, same issue.
What is in administrative side, we made the representation since 2016 to the Honorable Chief Justice.
Right.
No action has been taken, no communication even from.
Sir, this is a much more complicated issue than you think it is. This is the whole problem.
My Lord, Section 13 of Orissa Civil Code Act provides that if a matter is partnered, the same shall not be transferred, even if the territorial jurisdiction is created to another court is created and the
there has been no interim order. This petition has been pending for 6 years.
I have contacted with the senior member of the bar today morning. They said still several cases partnered.
What are several? Give us a list. Give us a list. What is several? Give us a list.
My Lord, the list is there. Your Lordship may kindly have a glance.
So you have not filed even an affidavit in the last 6 years.
Annexure 2 is the pending cases.
So these were pending when you filed this writ petition.
I will file an affidavit.
You file an affidavit?
Next week, Your Lordship.
No, not next week. This came on its own, sir. This bar association is not interested in all these matters.
My Lord, on several
No. I have been sitting as a Chief Justice for 1.5 years. Nobody has mentioned. Mr. Samal, have you mentioned this matter?
I had not.
So let's not go there at all.
Yes.
You have not, the bar association has not lifted a finger to have this listed. This is on its own, it got listed.
Oblige, I will file an affidavit. How many cases?
See, the tendency is always to blame the court for everything.
Your Lordship,
there is one tendency. I'm just saying, there's a tendency to say we are, as lawyers, we are correct absolutely. Only the judges and the court is wrong.
My Lord, prior to Your Lordship's period, Your Lordship,
since January 21, has there been an instance, Mr. Samal, when you have mentioned, I have not given a date? So let us talk of now, forget the past. You see, Mr. Samal states that he will file an affidavit updating the current status. List on 3rd November. All right.
Supplementary list item 34. Item number 34.
None appears dismissal no opposition.
Supplementary list item number 35.
35, Lordship, no instructions.
No instructions dismissed.
Supplementary list item 36.
This is a PIL matter. The grievance of the petitioner and their villagers to cause eviction of the encroachers.
Who are the encroachers, sir? Who are the encroachers? 4 to 7.
4 to 7.
There's a counter affidavit.
My Lord, in counter affidavit, in para 8 and 11 of the counter affidavit, the opposite part number 2 and 3 has specifically admitted that
have
encroachment, but taken the plea that there is a stay of eviction for 3 weeks as for the order in WPC number 10413 of 2017.
What is that? Where is that writ petition? It's before the single judge? But that 3 weeks stay must have got over by now.
Let it be listed along with that matter, my lord.
Sorry?
Let it be listed. This matter may be listed along with the WPC number 10413 of.
Is that a DV matter or a single judge matter?
So that even I don't know because that file is not.
What is that matter?
Disposed of.
It's already disposed of, he says.
2017.
On 2nd June 2017 itself, it's been disposed of. It appears that writ petition civil 10413 of 2017 was disposed of on 2nd June.
Right.
Huh? On 2nd June 2017 itself. And therefore, the so-called stay order, which was to last for 3 weeks thereafter, can no longer prevent the opposite parties from proceeding in accordance with law against opposite parties 4 to 7. Full stop. Nevertheless, since opposite parties 4 to 7 are not represented in the present case, despite service, a direction is issued to the opposite parties 2 and 3 to proceed in accordance with law to remove the encroachment only after sufficient notice and opportunity is provided to opposite parties 4 to 7. This direction is issued in view of the categorical stand taken in the counter affidavit filed by opposite parties 2 and 3 that there is indeed encroachment on government land by opposite parties 4 to 7. The petition is disposed of in the above terms.
Supplementary list item 37.
37, my lord, PIL for illegal encroachment and obstruction of Ketuapal Ganeshwarpur RD Road under Ali Tahsil in the district of Kendrapada, my lord. My lord, my representation at Annexure 2 is...
No, but you have not named the encroachers, sir. You have to name the encroachers. Permitting the petitioners to make a proper representation, naming the encroachers, so-called encroachers, and after following up on such representation, to seek appropriate remedies in accordance with law, the petition is disposed of.
Supplementary list item 38.
Item 38, Lordship, has become infructuous.
Okay. Counsel, the petitioner states that the petition has been rendered infructuous. It is disposed of as such.
Supplementary list item 39.
39, my lord, here the issue involves commercialization of the educational institution. In this particular case, my lord, the SOA University, my lord, due to fake placement, my lord,
Sir, all these matters are now infructuous. It's 5 years ago, right?
My lord,
if any cause of action survives, you make a fresh representation.
My lord.
You seek permitting the petitioners to make a fresh representation if any cause of action survives. Come up to the opposite parties and after following us on such representation to seek appropriate remedies in accordance with law, the petition is disposed of.
Supplementary list item 40.
I'm appearing for opposite party number 2, my lord.
All right.
Item number 40.
None appears disposed of prosecution.
Item 41.
May I please, your lordship. Item number 41, your lordship, in the nature of a public interest litigation. Earlier also the petitioners have approached this honorable court and this honorable court directed for disposal of my representation. Till date, your lordship, no action has been taken. And in the meantime, your lordship, more than 5 years has been elapsed and they also present status of the case I am to obtain. Present status of the case, your lordship, I am to obtain. That's why I pray let it come 1 week after so that in the meantime I will get proper instruction, your lordship. I pray, your lordship. Obstruction by OP number 7, your lordship. A piece of government land is not actually.
Where is the earlier order?
Earlier order, your lordship, in the petition, your lordship, the order was there since the representation was pending, your lordship, that was directed to be disposed of.
No, that was in 2013, sir.
Yes, your lordship.
And then you waited till 4 more years to file a fresh petition.
No, in the meantime, your lordship, I have communicated the order and time and again, your lordship, I am making representations. And every time, your lordship, even I have applied under the RTI and the RTI information I have.
Who has raised the unauthorized construction?
But OP number 7, Your Lordship. Unauthorized, Your Lordship, it's beyond the town planning area. And contrary to the town planning operations, and because of the unauthorized construction, Your Lordship, the entire area is getting flooded. Flood-like situation.
The earlier order, His Lordship, is at page 21.
Yeah, but what happened?
My lord, they had submitted a representation to the collector Bhadrap. So
What?
that
You have to find out, please.
Yes, my lord.
Both counsel for the petitioner as well as opposite parties need time for instructions. 10th November.
Supplementary list item 42.
Obliged.
Item 42.
I am appearing for the opposite party, my lord.
May I please, Your Lordship? Lordship, I kindly dispose of the matter as the opposite parties have already carried out the work.
Or counsel for the petitioner states that the work in question has already been carried out. The petition is accordingly disposed of.
Bless you, Lordship.
Supplementary list fresh submission item number 43.
None appears disposed in opposite.
May I pray for item 29, my lord?
So that has already gone past, so you'll have to wait.
Item 44.
None appears disposed in opposition.
Item number 45.
45, sir. Petition for eviction and demolition over the construction, illegal construction of the unauthorized construction over the government land, my lord.
Where's your representation, sir?
Yes, annexure 5, my lord.
What is that to show? Kindly listen to the question carefully. What is that to show this representation has been delivered?
My lord.
Nothing.
No.
So you make a fresh representation. Since there's nothing to show that there's been a delivery of the representation to the opposite parties, the court permits the petitioners to make a fresh representation and after following up with such representation to seek appropriate remedies in accordance with law.
Yes, ma'am.
The petition is exposed law.
Supplementary list item 46.
My lord, item 46, next week, my lord.
What's the matter about, sir?
Because there is some defect. I will remove the defect. Mr. Lawrence, Counsel, Mr. Ratsing is
Construction of Amrut Sarovar.
On behalf of him, I am praying for time. Is he ill, my lord?
Again, there's some representation.
Madam,
the petitioner's representation dated 16 June 2022 shall be considered by opposite party number 3. That is the collector Jagat Singh Poor. And after giving a hearing to the petitioners, pass an appropriate order, reasoned order thereon, not later than 21st November 2022. Copy of such order be made available to the petitioners within a week thereafter. The court clarifies it has not expressed any view of the matter.
Supplementary list item 47.
My lord, pardon, my lord, item 44, my lord. Just I was in the other court, my lord.
Yes,
Sorry,
tell us.
44, my lord.
Yes.
My lord, it is a PL matter, my lord. Your lordship kindly see page 11, annexure 2, my lord. That is representation to the collector Kendrapada. That may be considered, my lord.
All right. The petitioner's representation dated 4th August 2021 shall be examined by the collector Kendrapada. And after notice to the petitioners, as well as opposite parties 4 and 5,
my lord,
after giving them a hearing, a reasoned order shall be passed thereon not later than 21st November 2022. Copy of the order be made available to the parties within a week thereafter. The court clarifies it has not expressed any in the matter.
Obliged, my lord. Obliged.
Item 47.
May I please, my lord? My lord, this is a PL with pertaining to for non-uploading of FIRs in the CCTN websites, my lord. That is in terms of Honorable Supreme Court's order, my lord, is at page 17, my lord.
What are your representations? Annexure 4.
Yes, my
My
lord.
lord,
All right.
may I audible, my lord?
Yes. Receipt or AD
My lord,
card.
that is at the end, my lord. At the end, bottom, my lord, kindly have a glance to annexure 453.
Oh, I see. All
Page
right.
53.
All right. The petitioner's representation dated 25th June 2021 shall be examined by the Additional Secretary Home and a reasoned order shall be placed thereon. Additional Chief Secretary Home, State of Odisha, bracket opposite party number 4. And a reasoned order shall be passed thereon. Not later than 5th December 2022 and be communicated to the petitioner within a week thereafter. The court clarifies it is not expressed in view of the matter.
Obliged.
Appearance you have noted.
Yes.
Supplementary list for orders item 48.
My lord, 1 week time may be allowed to remove all the defects.
Or defects be removed within a week.
Obliged.
What is this? How is this a writ petition?
Yes, my lord. Similar writ petitions were filed and taken up by this honorable court on 2nd August and which were adjournment.
No, but why is it before the DB here? This is not a PIL.
Appeal has already preferred, my lord. Before similar writ petitions, many writ petitions were filed before.
No, why is it before this DB?
Yes, my lord.
Why is it before this DB? You're saying yes. What does that mean?
And the matters are adjourned by this honorable court.
Madam, this is not a matter to be placed before this DB.
This is OPID court. Where is that similar matter order?
Yes, ma'am. WPC 12705 of 22 and WPC 12707 of 22, WPC number 12935 of 22, WPC number 13517 of 22.
When are
these? This is the same matter which Lordship is dealing with, that RERA matter.
But
It
this
may be-
says some OPID court. They are complainers before the OPID court.
OPID court, correct.
My lord, 1 week time may be allowed and
When are those matters coming up?
only adjourned. I don't know.
What is the one? Give us one of the numbers.
Yes, I will give. WPC number 12705 of 22.
No dates given. But by our bench. Normally we don't give a date. How can we should not give a date? We never thought. All right. You see, defects we removed and list thereafter along with WP civil. Defects we removed within a week. List thereafter along with WP civil.
13517 of 2022.
13517 of 2022. All right.
Supplementary list item 49.
Item 49, I have filed the writ application challenging the order of the Green Tribunal, my lord. My lord, the brief fact of the case is, my lord, the petitioner is a lady entrepreneur. As per the scheme formulated by the state of Orissa, he applied and started civil construction, my lord. They have approved. The state government has approved as per their guideline, my lord. When civil construction was started, one person, co-villager, has gone to the Green Tribunal, my lord. The Green Tribunal, on the basis of the sitting criteria, that 500 meter criteria, my lord, they allowed the OA that the collector may be directed not to approve the poultry farm, my lord. My lord, while ordering that, my lord, the lordship come to page 59, he has gone excess of jurisdiction, page 59 of impugned order, my lord. Paragraph 13, directed the collector not to approve. Then, my lord, he has directed the civil construction I have made up to 40 lakhs to demolish the entire structure, my lord. At present, my lord, in view of the development made by the Central Water Board, my lord, Control Board, my lord, lot of changes are coming, my lord. I will, my lord, I am not challenging that part of the order, my lord. I will not seek for operating that poultry farm, my lord. But my civil construction, boundary, electrification, that has been directed to be demolished by using force, my lord. Your lordship, see section 15, that the construction will not pollute the air, my lord.
Why do you say that?
My lord, the civil construction I have undertaken, I will not operate the poultry farming, my lord, as per the order. But they have directed to demolish the entire structure, my lord. That is without jurisdiction, my lord.
No. If it is violating the environmental norms, then why should it?
My lord, I have not operated. In the middle, they have stopped. They have directed not to grant approval for operation, my lord.
Correct.
That part may be remain, my lord. I will not object, my lord.
What will you do with that civil structure?
My lord, I will utilize for any other scheme, my lord. There are other scheme also.
What scheme?
My lord, the other Mukhyamantri Krishi Vikas Yojana, my lord, they have other scheme here there, my lord. Cattle breeding, fishing. For the women, they are giving subsidized scheme, my lord. I may go for that. But the entire boundary structure, all the things he has directed to demolish, my lord. My lord, I will not go for that. My lord, invoke
file an affidavit saying that you will not do all that. You give an undertaking. Whatever you're telling now, you give it as an undertaking.
My undertaking is noted. I file affidavit.
No, you file an affidavit.
My lord,
Petitioner says that you file an affidavit.
My lord.
10th, sir.
My lord.
This is only on 10th.
My lord, tomorrow they will demolish.
How do you know?
My lord, the Tahsildar has collector directed demolish along with the police force and man and machinery, my lord. Let that be protected. I will file affidavit, my lord.
Counsel for the petitioner states that the petitioner does not object to the impugned order of the National Green Tribunal (NGT) insofar as it
operation of poultry farm.
Yeah, restrains the petitioner from operating the poultry farm.
Poultry farm, my lord.
In question. Full stop. However, the grievance is that the NGT has directed demolition of the civil structures, which, according to the petitioner, he is prepared to put to use for a different purpose, which is non-polluting. Full stop. He states that he will file an affidavit in that regard before the next date. He said notice. Mr. Mohanty accepts notice for
only for the state, my lord. Because since your lordship is not entering into merit.
Opposite parties. Number 2, 4, 6, 7.
My lord.
So many people, you just made everybody.
My lord, he has made 11 parties before the Green Tribunal. Only the chief secretary, my lord.
Notice to the remaining parties. No, 10. Notice to the remaining parties by registered speed post returnable on the next date. Paragraph till the next date of hearing. The impugned order of the NGT shall remain state. An urgent certified copy. Urgent copy be issued.
My lord, since it is tomorrow, my lord, the lordship may direct the government council to utilize his good officers. So tomorrow they will
copy of this order be communicated forthwith to the collector.
Collector Jharsuguda, my lord.
Jharsuguda by the
today intimation has to go.
Today itself. List on 17th October.
Well, I am filing the IA for dispense with the copy of the. I have filed.
You file it in the registries.
Well, I'll file affidavit. I'll do that. But I have made a heavy research. A lot of changes are coming on from 20 and 22, my lord. For every poultry farm having 5,000 baht, they want a restriction.
All right.
I have got the 21 policy. They have to formulate. If that way they will do, my lord, I cannot bypass that sitting criteria, my lord.
Right.
I have 15,000 baht. They say that from 5,000 that restriction has to remain.
I see.
residential zone category.
Right.
So I will forgo that project. So
Supplementary list for orders item number 50.
My lord, in item 50, I have removed all the defects except the filing of the
Limitation.
Because of dislocation for last 3 weeks, my lord, in my office. May I only take a time till Monday, my lord? I will file it.
All right. Mr. Mishra states that the defects will be removed within a week. List thereafter.
Deeply obliged.
Supplementary list item 51.
May I please, Your Lordship? Impun order is at page 65.
That IA 1840, you said there is no delay according to the SR. Application is disposed of. Impun orders were?
Page 65.
Yes.
That is regarding promotion during pendency of vigilance case. In similar cases, Your Lordship has issued notice and fixed it to 28th October.
Notice, you say, list on 28th November, October.
October.
Till the next date of hearing, the impugned order shall remain stayed.
Item 52.
That's item 52. Well, as this is with regard to regularization of contractual employees. Well, as similar matters are coming up on 14th of September 2022.
Okay.
This petition
Notice
writ appeals
on 14th September. The delay is what? Due to COVID.
It's during the COVID period. No, 61 days delay.
And don't, then IA number 236 that is allowed. He said till the next date of hearing, the impugned order shall remain stayed.
Whereas the lead petition is writ appeal number 777 of 2021.
List along with 777 of 21. All right.
Please. Supplementary list item 53.
There is no delay also, my lord. Disposed upon 16/11/2021.
Stated that on account of the COVID-19 period, there is no delay in filing of the present writ appeal. Then,
impugned order is at page 34.
Yes.
This is regarding that promotion during pendency of the vigilance case.
Same. Notice returnable on 28th October.
28th.
Till the next day, the impugned order shall remain stayed.
Supplementary list item 54.
Item 54, I appear for the appellant. The appellant here is impugning the order of the single judge because the single judge has refused to exercise his jurisdiction in relation to a writ petition filed under the Consumer Protection Act. The brief facts of this case is that, my lord,
so many defects, sir. Defects be removed within a week. List thereafter.
Let a date be notified, my lords.
You first remove the defects that will get listed after that. Yes.
Supplementary list item 55.
If I am appearing for the appellant in similar matters, my lords have already issued notice and granted interim order. I have producing the copy of the order.
Same order.
Here, my lord, I have filed one more IA for dispensing with the filing of certified copy of Annexure 2 and 3. Those are filed for reference only.
All right. That IA is allowed.
Supplementary list item 56.
May I please, Your Lordship? Your Lordship,
Filed
I
a memo for
filed.
withdrawing.
Yes, Your Lordship.
All right. The memo is taken on record. The appeal is disposed of as withdrawn.
Obliged, Your Lordship.
All right.
Item 57.
Item 57, as this pertains to regularization of daily wage workers. My lords, similar petitions are pending. My lords, if I may give.
All right. The delays due to the COVID-19 period, and that was condoned. Same order in the.
As these matters are coming on the 10th of October 2022.
Same order.
There's a delay of about 12 days. 12 days.
Item 58.
Item 58 and 59. May I play next week?
Similar matter
state
that I am.
Yes, I may be supplied a copy of the writ petition. I am appearing for Central Government.
Yes, item 58, my lord, similar matter was disposed of, my lord's matters.
That I'll take, Mr.
Yes. All right. List on 13th September. Give him a copy of that order also.
Item number 60.
You're in 60.
That is regarding that promotion during pendency of vigilance case.
Or delays condoned. 28th October, notice return on that day. Till the next day, the order should be next day.
There is a delay.
Yes, you've condoned that.
It will delay around 60 days because
condoned it, sir.
Condoned.
Supplementary list for admission, item 61.
Item 61 appearing virtual mode. 1 week time may be given to file the rejoinder to the counter.
Or a rejoinder will be filed for the next date. List on 18th. Sorry, 16th November.
Supplementary list, item 62.
May 62 item, my lord. This matter relates to filling up the posts, offices of presidents and members of different district consumer commissions, my lord.
Nothing survives, no, sir.
No, my lord. I have filed under RTI Act. I have obtained. I am filing an affidavit today, my lord. Under RTI Act, I have obtained. How many vacancies are there, man? 9 presidents and 38 members posts are vacant. And by the end of November, it will be.
Now there have been regular recruitment taking place. Sir, after you filed the petition, the whole recruitment has taken place. They've appointed certain presidents, they've appointed certain members.
Many district commissions are not functioning due to lack of quorum, my lord. Only one members are there.
Issue a fresh advertisement, sir. They've gone through one full round of advertisement. Selection is over. Are you aware of it or not? Are you aware there's a selection that has taken place very recently?
Oh, my lord, the last selection it has been completed 2-3 months back, my lord.
You're aware of that?
My lord.
See, it's not easy to find people to appoint. So they'll have to go for a fresh advertisement for the remaining vacancies.
Lordship may please to direct that they let them do something within next 3 months or 4 months.
It doesn't happen so quickly, sir. It's not like buying vegetables in the market. Selection is a huge process.
They should start the process.
They're already in the midst. They're already, it's all underway, sir. If they're not doing anything at all, these PILs are justified. Not now.
More than
during the pendency of the present PIL, one selection process has already been conducted for appointment of president and members of the various district consumer fora in the state of Orissa. Full stop. For the unfilled vacancies, a fresh advertisement is already contemplated. And the court has every reason to believe that that will also be taken to its logical end by appointing more chairpersons and members of the various district consumer fora. The court is of the view that the present petition has served its purpose. In the event that those vacancies remain unfilled for more than a year hereafter, then it will be open to the petitioner to, despite the fresh advertisement, it will be open to the petitioner to file a fresh petition in accordance with law.
Supplementary list, item 63.
Appearance we have noted we are on OP number 3 in this case.
Yes.
Solution.
Item 63, may I pardon your lordship? My lord, on behalf of Mr. BP Tripathi, on yesterday, my lord, mother of Mr. Tripathi, who is the amicus curiae in this matter, has passed away, my lord.
Oh, I see.
So Mr. Tripathi is not present in the court to assist the court. My lord.
The court is informed that Mr. BP Tripathi, the amicus curiae, has suffered a bereavement. List on 29th September.
Oblige, your lordship.
Supplementary list, item 64.
64, my lord, counter copy has been served on me, my lord, last week. I pray some time to file a rejoinder.
Rejoinder to be filed before the next date. 10th November.
Supplementary list, item 65.
May I please your lordship, I am appearing on actual mode, my lord. Here in this petition, my lord, writ appeal, my lord, I have challenged the judgment of the Honorable Single Judge, wherein the Honorable Single Judge, the facts are like this.
It says it's already listed on 28th September.
On that day, for some reason, it was allowed. Right? It was adjourned. The Honorable Court adjourned it because some judgments could not be filed. But I have
No,
filed
but the
the
cause list, it says this case stands adjourned to 20th September.
Because of contempt. No, now that a contempt petition has been filed, so I have mentioned it and before your lordship because a contempt is against me now.
All right.
Paying the money, Milos.
All right. You say this case already stands listed on 20th September 2022 till the next date of hearing. No further proceedings by way of. What is the contempt petition number?
My friend is there.
4436 of 2022.
No further proceedings shall take place in contempt case number 4436 of 2022.
Obliged.
All right.
Obliged.
Supplementary list item 66.
I'm appearing for the
appellant.
Matter regard National Law University.
That's right.
Appellant.
Appellant, right.
I don't know whether I should hear it. It's a list before a bench of which I am not a member.
That should be the Chancellor.
I know, that's right.
Yes.
On 26th September.
Let's.
All right. Interim order to continue. Right.
Supplementary list item 67.
1 second, right?
Thank you. May it please, my lords.
Yes.
I'll just take your lordships to page 167.
Yes.
That is the, my lords, issue here. And we see 167 of the writ petition. Writ petition. The prayer, that is the claim made against the respondents in general. Now, the first party is the, my lord, state of Orissa. Second party is the Department of Public Enterprises, who is the appellant here before your lordship. And the third is the Registrar Cooperative Society.
No, this is already adjourned to 22nd November, sir.
No, the urgency was this, my lord, that the arbitrator was proceeding and it was kept for final hearing. In the meantime, there has been one development I would seek to bring to your lordship's notice. Despite that, my lord, we would still like to press it because, my lords, in the meantime, pass on, order to pass on. My lords, in the meantime, Niagara Sugar Cooperatives, the arbitration has been suspended because of pendency of proceedings before the NCLT.
All right. Then anyway, it is suspended.
And no, my lords, that is true. That is true.
You say,
but anyway, my lords,
the court is informed that on account of proceedings before the NCLT, the arbitration proceedings anyway stand suspended.
Single Judge 25/8/2022's order.
All right. In that view of the matter, no interim orders are called for at this stage. List on 22nd November 2022, the date already fixed. All right.
Item 68.
The defect may be ignored, my lords.
All right. Defects be ignored. All right.
Obliged.
Item number 68.
68, I have filed a counter in this case, my lord, on behalf of NHAI.
You've already filed it or?
Yes, I've already filed. Copy of sought. Last occasion, he has taken time to file rejoinder.
Pass over.
Item 69.
69 for OP number 6 BMC. They have received the instruction recently. Manos, my grant 2 weeks time will be filing our detailed counter.
All right. Counsel, the BMC seeks and is granted. You are for, sir?
I am for the petition.
All right. Seeks and is
This is
granted.
the second time that they are taking time in
All
this
right.
case.
Final opportunity to the BMC to file its reply within 4 weeks, rejoined for the next date. 27th October.
Supplementary list item number 70.
70, I am for the opposite party. My lord, have decided the recent division bench judgment. My lord's judgment, it has been upheld. The issue in this case, whether the provision of the War We Act is applicable to the contractual employee. My lord, have already decided in the division bench. The single bench held thus, that is the under writ appeal. This case, paragraph 29-30 may kindly be seen, madam. Already, my lord settled that, and my lord's judgment has been upheld in the Supreme Court.
That's
I see this.
so far as so far as I am concerned, I am appearing for the appellate in the writ appeal number 152 of 2021. The question for consideration in that case where your lordship have decided the appointment of today I got the judgment also. The question was whether Shiksha Sahayak, which was appointed under a scheme, whether ORV Act will be applicable or not because of the proviso of that scheme. Here, the appointment has been made to the present appellants way back in 2009 under a statutory rule. Under a statutory rule where a provision has been made for not to make so far as the ORV Act is concerned, that will be applicable.
All right, let him examine it.
Yes, sir. Let me examine.
The only issue is whether the contract, that section 3D of the ORV Act, wherein there is a specific rider, the appointment in the contractual appointment, there shall not be no application of this ORV Act. This is the law laid down by my lord in the division bench. Then how the single bench judgment will be challenged in that? And it is confirmed in the Supreme Court. This point. And we are the beneficiary. We are suffering, my lord. Kindly see the writ petition is of the year 2000.
Right?
Yes, I am the respondent. I was the petitioner there, my lord. I have lost it, but now I am taking the advantage.
Mr. Samir Das, counsel appearing for the respondent numbers 2.
No, all the private opposite parties.
Okay, private respondents. I relies on the states that the issue in the appeal is covered against the appellant by the judgment dated 3rd September 2021 of this court in writ appeal number 86 of 2018, bracket Sri Sushanta Kumar Sethi versus State of Orissa, bracket, which according to him has also been affirmed by the Supreme Court of India. You have the Supreme Court order.
I've got to send it to Jaras. I will give
Mr.
it.
Rautre, learned senior counsel
Next
for
week I will
the
give.
appellant.
Appellant in
WP seeks time to
in the second case.
Examine the said judgment and make his submissions.
I am appearing WA number 152 of 2021.
This is all in 152 of 2021. Who's
Yes.
in 72 of 2020?
Same persons. A bunch of persons have been selected. They have filed separately.
But they should appear here, no?
Yes.
Mr. KP Misra.
Mr. Vigyan Sharma was appearing for one of the appellant. Mr. Kali Misra is also appearing one of the appellant. Transfer, keep it to some other day.
Next week, my lord.
Today you are also.
All right. List on 21st September.
Obliged. I'll give the Supreme Court judgment on that.
Interim order to continue.
The interim order is there. Interim order to continue.
My lord, I pray item 29 may be any date in the first week of September.
Supplemental list. I'm just calling.
We're just calling out one.
Supplemental list passed on matter item number 18. Item 18.
Mr. Rai, no? Despite a passover. You say a passover is sought in the first call. On the second call, however, none appears. This is item 18, no?
18, 18.
This was a non-passover. It has not even been listed once.
Item number 29.
Yes.
I pray in any day in the first week of September, my lord, we are unable to trace out the file, my lord. I'm sorry. And it's a problem in this litigation. So it may be.
Well, I'll just tell you what the issue is. Annexure 1.
My lord, we are unable to trace out the file. That's
1 minute. We'll just find out. Let us inform ourselves, sir. 1 minute. Page 8 to the ODA notice. Seat certification. What does it say? So if any cause of action survives, it's about the notification issued by the Seed Corporation, Orissa Seed Corporation Limited. Oh, so it's a demand notice. So how is it a PIL? How is it a PIL?
So a short date
It's
may
not
be
even
given.
listed once. Or only once it was listed, but there was a lawyer strike that day in 16, and thereafter it has never come up. So if any cause of action survives, you can file a fresh representation.
I have to take the instruction. A short date may be given in the first week of September, any day.
No, this is about release of payment towards cost of certified seeds of paddy during Kharif 2015, sir.
Yes,
This petition was filed way back in 2016, concerned as a PIL for release of payment towards cost of certified seeds of paddy during Kharif 2015. Full stop. The petition was listed just once on 5th July 2016, on which day it could not be taken up due to the lawyers abstaining from work. Full stop. Thereafter, it has never come up even once. Paragraph. In the circumstances, it is directed that if the cause of action still survives, it will be open to the petitioner to make a fresh representation in accordance with law and after following up such a representation to seek appropriate remedies in accordance with law. Petitioner.
May I please? Item 68.
Item 68.
68. I am the petitioner.
Yes.
Pray for 2 weeks time to file rejoinder, my lord.
What's the matter about salary?
The matter is regarding inordinate delay. The NHI matter. Press matter, madam.
Get past. I think he's filed a reply.
He has
The NHAI states he has filed a reply. Rejoinder to be filed before the next date.
My lord.
List on 22nd November.
My lord.
Oh. We come back at half an hour. We come back at 12. Or come back at 12.
person, the sixth person has been convicted by the London trial court only on the basis of evidence PW1 and PW10. PW10 is the doctor and PW1 is the eyewitness, the brother of the deceased madam. The brother is the interested witness.
Yes.
And as for the prosecution, he is the eyewitness of the occurrence, madam.
Right.
I may be permitted to place the evidence of the PW1, madam.
All right.
Deceased. Dharma Hentala was my elder brother. I know all the accused persons who are standing in the dock. The occurrence took place about a year and 8 months back on the Monday at about 7 p.m. On that day, as per the previous arrangement, I had been to Subei weekly market and waited for my elder brother, the deceased, to arrive. He came to that place.
You're reading PW6,
my lord.
You're reading PW6.
PW1, my lord.
One.
My lord. Page 131, my lord.
All right. Yes. Yes.
He's the only witness on the basis of the PW1, evidence of the PW1, the appellant has been convicted.
Right. Hari Hantal.
He came to weekly market, waited my elder brother, the deceased, to arrive. He came to the place and got down at about 5 p.m. Then we had tiffin together and by 5:20 p.m. proceeded towards our village on foot. On the way, we reached the village Guntuput at about 7 p.m. The villagers were observing Pausha Purnima in that village. Man and woman were dancing together in that festival. All these accused persons were also participating in that said Dhamsa Nacho. We stopped there to watch their dance for some time. Then I called my deceased brother to leave the place and go to our village. Hence, hearing which the villagers of that said Guntpada became angry and abused us, all alleging that we are calling female of their village. Thereafter, we left the village and villagers chased us. There are about 15 to 20 pupils chased us. All the accused persons are along with them. We ran towards village Bankaput, the petitioner's village, madam. This is village, in the hope of getting protection there. While we are running to our life, I was ahead of my deceased elder brother. He was few steps behind me. Then we reached Godam Nalo. The accused person were right behind us. Then the deceased told me to jump into the water first, and accordingly I jumped fast in the water, crossed the Nalo. My brother was to jump after me. At that time, the accused person caught hold of him. After crossing the Nalo from the other side, the bank, I saw that accused Balaramo Panasaputia, Hari Panasaputia, such and such person, were assaulting my deceased brother by means of lathi and knife. At that time, my deceased brother was crying, Balaramo, don't kill me, spare me. About 6 persons out of them chased me and threw a lathi at me, for which I fled away from the spot. On reaching our village, I narrated the entire incident to my parents, Sasidhara Patnia, Kamlu Patnia, and such person. About 9 p.m. that night, myself and other villagers, along with my parents,
left for
Guntuput.
My lord.
Left.
My lord. Left for Guntuput. We reached the village Guntuput at about 10 p.m. There we found that my deceased brother was sitting in front of the house of Bisu Gudia. That accused Duru Samantra and others were trying to make him drink pejo. The pejo is the rice water. Rice water, my lord.
Rice water, correct.
My lord. We also found that a rope was tied to his neck and there was no injury on his head. There was an injury on his head which was bleeding profusely. My elder brother Dhana was not able to speak at that time. Seeing us, this person left my deceased brother and made him lie near the house of the Bisu Guntia, and then they left the place. Then we sent Kirmani Bairagi and such person to get a vehicle to transport the injured to hospital. My brother breathed his last after about 30 minutes of their departure. That night we guarded the dead body of the deceased, and on the next morning myself, Saddam and such went to Nandapur police station to lodge the report. I appeared before the OIC Nandapur PS and orally reported about the incident, who recorded my statement and read over and explained the same to me. Finding it to be correct, I signed the same. Exhibit 1 is the said report, and Exhibit 1 by 1 is my signature. Then police came to village, Guntuput, held inquest over the dead body. I handed over the rope which was tied to the neck of the deceased to the IO at village Guntuput. He seized the same. About 50 to 60 days after the incident, I went to the district jail Koraput in the test identification parade held at Koraput district jail before the magistrate. I identified 8 persons to be the assaultant of my elder brother. Right. Accused person's name is there, my lord. 8 persons whom I identified to be the member of the unlawful assembly who assaulted my brother on the day before the magistrate in the TI parade. I have not seen those accused person in the meantime. That is after the TI parade, and I have seen them in the court for the first time after the TI parade. MO1 is the rope tied to the neck of my deceased brother. That's cross-examination. I had no prior relation of accused acquaintance with the villager of Guntuput. We had no business dealing with those villagers. We had never talked with any of the villagers of Guntuput. I could know the name of the 8 accused person who have been named in the FIR. When we went to the rescue our brother from village Guntuput after the incident of chasing, at that time the investigation, I identified 8 persons who have been named in the FIR in the presence of the police. Very important. I could not know their name. When the police asked the accused, accordingly, I named their name in the FIR.
Mention their names.
My lord. And after the police asked their name, they informed the police, and police written the name of the accused person, my lord. About 15 to 20 persons chased us. Our village is situated about 3 kilometers away from the village Guntuput. Village Bagput is also situated at the distance of 3 kilometers from the Guntuput. There is no separate road from Gunput to our village, excepting the one which passed by village Bankiput. There are two nala in between Gunput and the Bankiput. Goda Nala is situated near the Gunput, whereas Gundam Nala is the situated near village Bankput. The Goda Nala is summarized in the Upper Kola project. At that time, there is no water in the Godam Nala. The said Nala is the important one. At that time, there is no water in the Nala. And said Nala is about 14 to 15 feet deep, and the weight is the same, would be 30 to 40 feet. The accused person were chasing us in close distance from us. They were shouting at the top of their voice of Mara Dharare. By the time of reached the other side of the Nala, there I saw them assaulting my deceased brother. At that time, also the accused person were shouting, and some of them chased me. After reaching the other side of the bank, I did not wait for my brother and ran to my village. I could know that my brother could not cross the Nala after reached the other side of the embankment. I did not see any other person at the place. It is not a fact that at the time of incident, when I look back, I heard my brother shouting that Balarama, that is the Balarama Panasaputia, don't kill me and spare me. It is not a fact that I have not stated before the IO that on reaching the Nala, my brother asked me to go ahead. No panchayat was held at the village Gunput, as the accused person were not present, nor their males of the village were present. By the time we reached that village, only female folk were present. It is not a fact that we were not reached by the accused person, chased by the accused persons that night. It is also not a fact that the accused persons did not kill my brother near the Gunput Nala. I have not convict in. I have been convicted, sir, in a rape case. I have been convicted in a rape case. I have been convicted in a rape case. I have already undergone the sentence for about 8 months. It is not a fact that myself and my brother went to village Bankput and the village Gunput to commit theft. It is also not a fact that we stole a goat, killed it and throw the carcass. At that time, the villagers of Gunput chased us. It is not a fact that police found a dead goat near village Gunput, which while it was investigating into the case. I only signed my name. I cannot read the right. It is not a fact that I am deposing falsely, being instigating by the police. It is not a fact that I am deposing falsely as the villager of the Gunput did not keep my request to assault us, assist us in committing theft. This is the statement of the PW1, my lord.
What is wrong with it, sir? What is your comment?
My lord, PW1 has stated that when he was running and his brother was in his back, his brother told him to jump the Nala. And the informant jumped the Nala, and it is the 14 to 15 feet deep, my lord. For that reason, he has injured, my lord. And he has, in the further process, he has stated, I sustained an injury on my left knee as one of the assault through lathi at me. So he was injured, my lord. And the that night, 7 p.m. in month of January is the night, my lord. It is not possible 30 to 40 feet distance to identify a person who has assaulted his brother, my lord. As for the medical evidence, the lordship may peruse he has categorically.
Doctor. No, so you have nothing more to say on PW1.
PW1 is the only, he has told in the his evidence that my case is the at the time of chasing the villagers of Guntpur, they jumped the Nala and sustained the injury, and due to the injury, the deceased has died. The BW medical evidence has, in your lordship may peruse the page 153, my lord. Here's para 5, my lord, in cross-examination. It is not necessary that in order to result a injury like injury number 16, a heavy weapon should be used. Injury number 16 to injury number 16 to 19 are the main cause of the death of the deceased. All the injury can be possible by fall from the high place in which the deceased rolled and hit many objects, my lord. As for the medical evidence, when the deceased advised the informant to jump into the Nala to save him, and after he accused must have jumped as per his advice, jumped to the Nala, and at the time of jumping he sustained the injury, and due to injury he has died, my lord. That is my case, my lord. And the learned court below.
Why should we disbelieve PW1?
Your lordship may peruse the judgment of the learned court below has observed that no prosecution has not proved his case. So who has been assaulted? Who has been assaulted to the deceased, my lord? Only though the accused person village and informant village is nearest, and they know the persons, my lord.
All right. That's it,
my lord. And two independent witness has been examined, and he has also stated that it is a dark night. Seven. PW7 has stated that it's a dark night.
Yes, Mr. Katkar.
Yes, sir. The only eyewitness is PW1, as well as has already read out. And he has uttered the name of the appellants who have been convicted and who are here before lordship. That is at paragraph 2 and page 2 is running page 132 of the paper book.
Yes.
Of course, my lord has read out, but I am again repeating it. After crossing the Nala in the middle, after crossing the Nala from the other side of the back, I saw that accused Balaram Ponsupati, his appellant number 5. Then Hari Ponsupatia is appellant number 6. Turi Samara, appellant number 3. Kamulu Doru, appellant number 4. And Padu Budia, appellant number 2. And Vishu Budia. and others were assaulting my deceased brother by means of lathis and knife. At that time, my deceased brother was crying, Balaram, don't kill me, spare me. So there is also a dying declaration to that extent. Of course, he has taken the name of Balaram. This is Balaram Panaspatia, who is appellant number 5. But the witness has seen all these appellants along in the company of others assaulting the deceased, and there was the deceased was shouting, and nothing substantial has come up in the cross-examination to support the defense. Rather, at paragraph 13 at page 136, it has been stated by that witness that it is not a fact that myself and my brother went to the village Bankaiput and village Guntaput to commit theft. It is also not a fact that we stole a goat, killed it and threw the carcass. At that time, the villagers of Guntaput chased us. So his presence rather was a motive, and also his presence at the spot that has been brought out in course of the cross-examination. And if a lot will come to the medical evidence, the doctor being examined as PW10, that is available at page 150. So many injuries are there, maybe abrasion, contusion, and also one incised wound is there. And there is a linear fracture of skull of temporal bone, left and right parietal bone, and also a depressed fracture, spindle shape of right parietal bone in the middle area, and disruption of 3 membranes that is available at page 152 with massive hematoma in epidural, subdural, and subarachnoid space underlying depressed fracture area of right parietal bone. And as has been stated by the doctor, all the injuries found by me were antemortem in nature. The cause of death is due to injury to the important organs like brain and membrane with hematoma. Time of my postmortem examination, since death is 42 to 78 hours, matches with the type of assault. The internal injuries are sufficient in the ordinary course of nature to cause death. In my opinion, the death of the deceased was homicidal after the postmortem examination. Similarly, the PW1 version is well corroborated with the version of the doctor. And PW7 has said a moonlit night, what my learned friend has stated, just I am answering to that part. About, it is 147.
Yes.
About paragraph 2, paragraph 1, I know all the accused persons. I was not acquainted with the deceased. About a year and 8 months back, one night, myself, PW6 and Mangala Pangi went near the Gundam Nala as we heard some shouts from that side. The accused persons who belong to village Guntaput were chasing the deceased near the Gundam Nala. It was a moonlit night. Of course, the next paragraph, when I arrived near the Nala, Pandam Gunta was already there. It was a dark night. In the darkness, we shouted about the identity of the person standing there, to which the people standing there replied that they belong to village Guntaput. Those people further stated that they have come to catch hold of a goat thief. So even if it is a moonlit night, it's not possible to recognize all the persons because there are so many persons they have chased. And chasing has been proved by PW7. And also PW1 has stated that he along with his brother were chased by the villagers of Guntaput. And if a combined reading of PW1 along with PW2, it can be well presumed that it is due to the theft of a goat. Probably both have been chased by the accused persons along with other villagers, and ultimately the deceased has been assaulted to death. And remaining, most of the witnesses have turned hostile.
4 and 5 has declared hostile.
4, 5 also 4, 5. 6 also hostile.
No, 6.
Not it.
4 and 5.
5. The prosecution and they have been put to TI parade, of course, plus the STGM Koraput has been examined as P2 13 at page 159. And as an may I read it?
I mean, what is significant? Blood group matches?
No, identified. The same witness identified the accused Shukura Panusupotia correctly in the first chance under Exhibit 9. Similarly, the state witness examined accused, all have been identified. Because nothing, he has not stated anything that he has not been identified, because all these appellants have been identified. And there are 6 appellants have been convicted. So there is.
Your Lordship may peruse the page 33 of the paperwork, the judgment of the London Court below, para 17, my lord. It is clear that 6 accused persons, along with some other whose identity could not be established by the prosecution during the trial, have committed the offense or rioting with the deadly weapons. And also, in last May, as there is no direct evidence as to who is the author of the injury, which lead to the death of the deceased, or in other words, who is the author of the particular injury, which alone caused the death of the deceased, my lord. So prosecution has not proved his case, who has assaulted the deceased and which person has assaulted, my lord.
Yes.
Out of 15 persons, only 6 persons have been convicted, my lord.
All right.
But regarding the TI parade, nothing that has not been questioned.
Right. All right. Orders reserved. All right. Yes, Mr. Rai.
There was an password item 18.
Correct.
And there is no lodging, my lords.
Yes. Anyway, that's not your listed ones.
My lords have left us. So we are having no home. We are homeless. And this is scorching sun, my lords, is affecting us. So I hope your lordship will accommodate us for some days before vacation so that it will not get dry.
All right.
I am actually I am happy that the case has been dismissed.
All right.
I have been free from that burden.
All right, sir. All right.
I'll only mention one matter at 2 p.m.
All right.
Plus one instruction I had received, so far as that matter is concerned. 2 persons have died in the meantime. Padu Patnaik and Doru Sumra.
That's right. 2 are still there in the field.
Yes, 2 and 3.
Correct. That he also mentioned.
Yes.
Anyone else? Any other matter?
Mr. Samir Mishra wanted to conduct one case.
Mr. This one is there. Shaktidhar Das. Yes, sir. Item 7.
Last week, my office said unless there is a order,
He was there, suddenly gone. There he is. Mr. Das, you can begin.
Hello, my lords, can I unmute you?
Yes, you are audible.
Yes, my lords. I had prayed for your lordship because I have lost my paper book somewhere. Your lordship had permitted me to get my copies from your lordship.
Right.
Last pen drive. They said that unless there is an order, we will not give. But today they have taken my memo and also, but not pen drive. Can I pray any day next week? But on my appeal memo itself, I have prepared a note and given your lordship.
All right. Today you'll get it, sir, because we have given instructions to the Registrar Judicial. He will give it to you. No problem.
Obliged. Highly obliged. Any day your lordship may post it, I will complete it.
No, this will remain on board, sir. Whenever you are ready, we are ready. So
no, the day after tomorrow, I will do it.
All right.
Yes. 3 matters.
Day after tomorrow is holiday.
Day after tomorrow is holiday, my lord.
Whenever we sit next.
Plus, 3 matters can be disposed of because all 3 appellants have died.
All right.
It's
Tell us.
item 46.
Item 46. CRL 115.
CRL 115 by 2002.
Right. Court is informed that the sole appellant has expired. The report of the IIC Jharsuguda PS dated 23rd August 2022.
That's item 62.
This is 46, Monumunda, right? That certificate has also been enclosed. Accordingly, the present appeal is this post office having a waited.
Item 62.
Because on the other side, the death certificate is there.
All right. And this is the sole appellant has died. Same.
And item 63 also.
63. Jharia Jena. All right. Anyone else? No. What happened to that 1, 2, 3 and all? 1 is of course 6th.
1 is 6th September.
Order is reserved. 3 he took time. That took time. 4. You call it 4.
Weekly list item number 4.
This is Dharnidhar Nayak. Right? Nayak must be there.
Weekly list item number 4.
There are 5.
Item 5. 5 also.
No, 4. There are 4 connected methods. We again do this exercise of finding whereabouts. Mr. Katkia?
Well,
this item 4, it's a 1996 matter. Can the IIC tell us there are 4 appellants there?
Yes, yes. What is
No. Item 3, I have some instruction, madam.
3.
Item 3. There were 4 appellants. Sorry, madam, 3 appellants. 3 connected appeals, my lord.
In which one? Item 3?
Item 3, my lord. Criminal Appeal 123 of 1996.
Correct.
It has connected. There are 3 appeals, my lord. Criminal Appeal 123. Criminal Appeal number 137.
Only 2.
And the third appeal, my lord, one Alam Uma Shankar Rao, he is expired, my lord. In criminal appeal number 137 of 1996.
Correct. So only Mehdi, there are 2 appellants.
There are 2 appellants.
What is their current status? Actually, in this, I think Mr.
This
Dalit
we had
took time.
received in 9/9/2020, my lords.
No. See, in this, Mr. Dalit took time yesterday.
He took time.
So I'm talking now about 4. 4 has 4 connected criminal appeals. Item 4.
Yes. Criminal appeal 227, Uddanath Pradhan, my lord. He is dead.
He's dead.
He's dead.
Oh, so 227 of 1996. When did he die?
We received this instruction on 10/9/2020, my lord.
Oh, poor.
The appellant has already died.
All right.
May I please your lordship?
Yes, yes.
And
in item number 4, my lord, 32 accused persons has, my lord, convicted under section 302 IPC, and you have filed the 4 sets of appeal, my lord. In the meantime, my lord, 1/3 of the total numbers of appellants have already died, my lord.
I'm
So
just
tell
saying,
us, tell
I'm
us
just
which
saying
ones.
that.
I have to take instruction.
No. She's now giving us those details, sir.
A criminal appeal number 233 of 1996.
No. So 220. Let's do one by one. 227 of 96.
Uddanath Pradhan is dead.
Uddanath Pradhan stated have died on.
No, that date is not there.
All right. Counsel learned AG informs the court on instructions that the appellant is dead. Sole appellant is died. The appeal is accordingly disposed of as having awaited. Now, 232.
Criminal appeal 233. 32, the appellant is alive. And reportedly residing in village Raghunathpur with his wife and son. And criminal appeal
in criminal appeal 227, there are 7 appellants.
My lord, instruction is that only Uddanath Pradhan is dead.
All right.
If your lordship will direct, I'll take fresh instruction also. But there are others also. Let me finish.
All right. You say criminal appeal 227. You say the appeal abates as far as appellant number 1, Uddanath Pradhan is concerned. All right. Then in 232.
233 of 1996.
Just see that.
Makadam Sahu.
There are 10 appellants here.
12 appellants.
12 appellants. Correct.
In that, Makadam Sahu has died.
So you say the cause title of in the first matter, you say the cause title will now read as Kartika Chandra Swine and others. In 227. In 233, you say Makadam Sahu has died. The cause title will now read as Gandhi Raut and others. Then
in criminal 268, Kulamani Naik, he is died. Sole appellant. All right. In 268 of 96, you say the sole appellant, Kulamani Naik, is stated to have. He died on 7/6/2019.
Expired on 7/6/2019. Accordingly, this appeal is disposed as having awaited.
State may take fresh instruction, my lord. As per my instruction, 10 to 11 appellants has already been died. In the meantime.
How many appellants?
10 to 11 appellants.
Counsel, the appellant says that more than 10 to 11 appellants have meanwhile died. However, the IIC of the concerned police station is directed to file a detailed report in this regard.
Current status
on the current status.
Yes.
The report be called for by 12th September.
After Puja vacation,
No, for this it should not take very long, sir. List on 12th September. So 268 of 96 is awaited. Item 5.
Item number 5.
5 is also same, my lord. Out of 12 appellants, 3 to 4 person has died. I am not sure, my lord, who has died.
So we put down your name, S.K. Das, for other appellants?
On behalf of Mr. D. Naik, my lord.
Right. Mr. S.K. Das on behalf of D. Naik. Here again, you say Mr. Das states that many of the appellants have expired. Just see how many appellants need.
5.
Five appellants. And in the second one, 47 of 98. The IAC, the concerned police station, will file a status report. Sarangkul, please. Will file a status report of the current position vis-a-vis each of the appellants in both these appeals. This also you call in
Your Lordship, may hear it on any date on in October. Milord.
No, first let us find out, sir, which appellants are there, not there, and all that. And these are very old matters, sir. So no point in simply adjourning.
Milord.
Rather complete it. No, this is calling for the report. This is calling for the report. This is not the report. No. So in this, there is a report. This is in 47. What is the first item? Okay, shown this. In item 5, there's a report of the IAC, Sarangkul PS, dated 22nd August 2020. Stating that criminal appeal 47 1998. Appellant number 2, Vidu Rushin Patnaik. Appellant number 3, Harisha Pradhan. Appellant number 5, Abhi alias Abhimanyu Pradhan. And appellant number 6, Ladu Kito, sir, have expired. The appeal as far as the aforementioned appellants are concerned. Disposed of as a regular. The appeal will continue as far as the other 3 appellants are concerned. This is only in 47. In 193, the same thing. On 12th, call on 12th.
Item number 8.
Item number 8, Lordship. My
Yes.
Lordship is a hard matter. May I pray for after lunch?
All right.
Item number 9.
Is your Lordship.
After lunch.
Because I am there in item 9, my lords.
Yes.
I have a viral fever, my lords, and a sore throat.
Then we'll call it some other day, sir. Not to worry.
I am praying for all my matters to be taken up a week after.
All right. All right. No problem.
Much obliged.
All right.
Item number 10. Item 11.
My lord, on behalf of SN Sharma, kindly taken up after lunch, my lord.
All right. Sir, in item 10, what's the current position? How many appellants are there in that? 3 appellants.
We had called for instruction, my lord. We have not received.
I think in all these, you should automatically ask for instructions.
Yes, my lord, we'll do that now.
Already we have sent letters.
At least we had sent letters are there. We again have to send reminders.
Right.
And especially in all those old matters, we'll take a priority to
Correct.
find out the.
Correct. Anyone else in any matter?
Item 20, I am there, my lord.
Yes, sir.
Lord, I am ready in this matter, but the difference is after lunch, I have got a matter which is fixed before another bench, which is a part-time matter.
Achha.
If your lordship takes on Monday, Tuesday, any day, I am ready. I'll do it.
All right. We'll do it on Mondays. Not a problem. All right.
Monday.
All right. We'll come back at 2. All right. Come back at 2 o'clock.
I may be permitted to mention matters. On 29th of June, I could not bring to your lordship's kind notice that the moratorium was over after the NCLAT judgment.
Oh.
That was my mistake. So the calculation has to be, the water tax calculation has to be made from December 18 to June 22. So, my lord, this sitting with Justice R.K. Patnaik.
So we'll have it on a Friday.
On Friday. I have paid the amount. As per lordship direction, I have paid 1 crore 66 lakhs. Only thing is that the difference can be adjusted towards the security deposit balance.
IA, you filed an IA?
Yes, I have filed an IA.
All right.
Much obliged. That was my mistake.
All right. All right. No problem.
Sorry, my lords.
No problem.
May I be pardoned, my lords?
So, Panda.
Yes, my lords. We are in 525 of 2007. My lords are allowed to file written notes.
Correct.
I'm filing the same.
Yeah.
And the copy has been served at this.
All right.
It may be taken on record, my lords.
Yes, yes.
Deeply obliged.
All right. Mr. Samir Mishra.
My lord.
Quickly, item 8.
Yes, sir.
May I please, your lordship?
Yes, please.
Here the conviction is under section 302, reading section 34 of the IPC.
Yes.
They have been sentenced to undergo arrive for life, your lordship.
Right.
I beg to point out, my lord, I had filed a written note on earlier occasion. I think it is on record.
Right.
I had just to place the facts. Here, I would like to submit that there is no direct evidence on record with regard to the accused person killing the deceased.
Right.
The case is based on circumstantial evidence, which I will demonstrate. EW2, who claims to be an eyewitness, during the deposition in court, happens to be an exaggerated statement in court, which was not available before the police. And the police has also stated that he had never stated so before the police. Now, my lord, the prosecution case is based on the FIR lost by the father, who could not be examined in court because he had passed away by the time the court examination was done.
Right.
He says that on 2021 night, that is April 1998, they heard a sound outside and they came out, both the father and the daughter. Daughter is PW2.
Right.
And they saw Bimbadhar lying in a pool of blood.
Right.
The FIR itself reveals that they saw these three accused persons running away from the spot being armed with a barcha.
Right.
Though the FIR is in
what is a barcha?
Barcha, my lord, in my humble submission, subject to correction by the State Council, is a kind of javelin kind of thing. That is a
javelin. Oh,
it's
spear.
Spear kind.
Spear. My lord, barcha. That is what FIR says, and they say that they saw these persons running away from the spot.
Right.
Not to assault or anything has been stated so far the FIR is concerned. Now, on the basis of this FIR, and a motive was also attributed, saying that this Harasa was the control dealer, and he had threatened that if the deceased would be appointed as a control dealer, then he will be they will take away his life. This is what the prosecution says in the FIR itself. The purpose of pointing out the motive is, well, the case is based on the circumstantial evidence. I'll demonstrate from record that the prosecution witnesses have tried to develop the case in a better way before the court during their examination. And, my lord, the motive the prosecution has failed to establish in a case of this nature, where the prosecution makes motive as a ground for the purpose of sustaining a conviction and fails to establish, then the rest of the evidence is to be looked into very rigorously, and particularly when there is no direct evidence on record. This is what I beg to point out to your lordship, my lord.
Right.
My lord, now so far as this control dealer aspect is concerned, motive, except a bald statement, nothing has been produced. Either the deceased was appointed as a control dealer, or the present appellant number 1 for your lordship was disengaged as a control dealer. There is nothing on record. And a defense witness has been examined on behalf of the defense, who has said that nothing that sort of change had happened. And nothing has been produced by the prosecution to show that in fact such a thing had happened so as to derive a motive on the part of the appellant for the purpose of committing this act. Now, Your Lordship, the primary evidence which the prosecution relies upon is the evidence of PW2. That is the sister of the deceased, Your Lordship.
Yes.
Because the father, having passed away, was not examined in court, my lord, though the father happens to be the informant. Now, Your Lordship will kindly turn to the deposition of PW2, Your Lordship.
Right. Parvati Behra.
Much obliged, ma'am. Parvati Behra, that is at page 47 of the paper book, my lord. Here, Your Lordship will kindly turn to page 48. At the top, he has said, may I read it out, my lord?
Yes, please. Yes.
Both myself and my father went near the sleeping place I'm sorry, of my brother. We could see that accused Haraso and Sarata with Bhujla, that is Bhujali, they have said, which is a different kind of weapon from FR, because FR they say Borsa. And accused Prakash with Thenga assaulted to my brother. We say Borsa to Bhujali. He has tried to explain. After stabbing by means of Bhujali, they ran towards canal side. My father shouted, holding the name of the accused persons, Prakash, Sarat, Harsha, are going away after stabbing Bimadhar. Then paragraph 3, that motive that the brother was appointed as control dealer for which this act was done, that is what she has stated. Now, Your Lordship will see paragraph 4 towards middle, towards the last 3-4 lines, suggestion has been given to her that she has never stated so before the IO with regard to this grudge or with regard to this assault made by the accused being seen by both the father and the daughter. IO also, I will point out, my lord, has admitted that this witness has never stated before him that she has seen the assault. So that is why I was submitting for Your Lordship. At best, if at all this statement is accepted, then what they have seen is the accused persons running away from the spot, being armed with a weapon. And
but that is Section 6 Evidence Act, no?
Much obliged, ma'am. Now, my lord, what has happened, Your Lordship will see, and whether that can be accepted in the context of what the prosecution has projected and has failed. My lord, here Your Lordship will kindly consider one thing, that so far as this entire prosecution version is based on PW2, because there is no other material where no weapon of offense has been seized. Yes. Now the doctor says this kind of injury is possible by crowbar. So therefore, on record, 3 kind of opinion with regard to the weapon of offense, namely Borcha, then Bhujali Thenga, and crowbar is coming forward from the evidence of the prosecution witnesses.
Yeah, I think what is common is sharp-edged weapon. That's all we have to see.
And
are there cut injuries, incised wounds?
And that is to be also considered in the context of the fact that the appellants were arrested from their house and no weapon of offense has been seized. No weapon of offense has been seized and produced by the.
But that is again not relevant, Mr. Mishra.
But that will be relevant in the context that except the fact that they were running away from the spot, that is what they said, and whether this running away from the spot can be accepted when she has resorted to falsehood by saying that she has seen the assault, which has been denied by the IU.
Right.
And she has also been suggested so far as her statement in 161 CRPC is concerned, where she has not stated such kind of things. And whether this part of the statement running away from the spot can be segregated for the purpose of accepting it. And this is what I will beg to submit for Your Lordship, though I am conscious of the fact that this principle of falsus una, falsus omnibus may not be entirely applicable so far the evidence is concerned.
Correct.
But it is subject to the rider that the court must be in a position to separate the grain from the chaff for the purpose of accepting the grain for the purpose of sustaining a conviction.
Right.
If at all, my lord, this plea can be segregated by reading this statement that has been made in paragraph 2, my lord.
So basically, she has told the police that she saw them running away.
Yes.
She did not tell the police that she saw them stabbing.
Yes. Now here she gives a statement where she says they assaulted, then they ran away. My humble submission is so far as this paragraph 2 is concerned, the statement is so intermingled that it cannot be separated for the purpose of believing to the extent of she having seen the accused person leaving the spot. Number one.
If you reconstruct the scene, they hear the brother shouting.
Yes.
And then they go there because they hear a sound from the side of the house. See, that's how it happens. So let us take it that while he was being attacked, he shouted. Hearing the shout, the father and the sister go there. By which time the stabbing has already taken place and they're leaving the place with their weapons. So it's very natural that when they reach the place where the brother was sleeping, they see them running away. They don't see the actual assault.
Exactly, Your Lordship.
So is this not, this is a continuous narration which makes sense, doesn't it?
But my humble submission would be, there has been a drastic improvement, which in my humble submission will amount to a material contradiction. Because, my lord, what she has done...
It's not a contradiction. It's not a contradiction.
And there are two aspects. Omission may amount to a contradiction, my lord. Here, my lord, what she has done...
No, this is an embellishment. This is not an omission.
My lord, I stand corrected to that extent. If this is a case of, my lord, exaggerating thing in court because of the fact that she wants to sustain a conviction. And this is what I admit because...
Correct. Anxious that they should not get away.
Pardon, Your Lordship.
Anxiety that the accused should not get away.
Much obliged, Your Lordship. Now, my lord, so far as this statement that the accused were running away from the spot they have seen, my lord, so far as the informant is concerned, he is not there. So the entire thing is based on PW2.
Correct.
This also cannot be accepted for the reason because they have said after they saw this incident, they raised holla, other persons came into the place. And Your Lordship, PW2 and PW6 have been examined by the prosecution to show that they reached immediately after the incident, Your Lordship.
Yes.
And Your Lordship will see they have been declared hostile by the prosecution because they have not supported the prosecution version.
Right.
And so far as the statement of PW4 is concerned, that also negatives the plea of, my lord, this PW2 to the extent that they saw the accused persons leaving the spot. But that is the specific case in the FIR. And I will just point out also how the FIR on the face of it also cannot be accepted. My lord, because of and that I will point out. But even assuming that the FIR allegation that the prosecution case that they saw the accused persons leaving from the spot, that also cannot be accepted for the reason, Your Lordship, the PW4, my lord, she has also stated that nothing that sort has been stated before the witness after they reached the spot, because that is the case of the informant and the sister of the deceased, that is PW2, that they disclosed that the accused persons were leaving the spot. Now the PW1, the mother, though she claims to be an witness, post-occurrence witness, my lord, Your Lordship will find that is not on the face of it acceptable, where the IO has said that she was not present, and except the informant father and the sister, PW2, nobody else was present when the police reached the spot. So therefore, the claim that they had disclosed it to others also gets falsified, my lord, from the statement of the IO. Because IO has specifically stated, and in my written note, my lord, I have specifically indicated the page number of the paper book and the paragraph where these statements have been given. And I don't want to, my lord, bother Your Lordship by again taking it to those statements, my lord. But this is the statement subject to correction by the State Council. Now, my lord, so far as the FIR is concerned, Your Lordship, FIR has been written by PW5, Your Lordship. FIR has not been either, my lord, stated before the police by... I'm sorry. And the FIR has been written by PW5.
Right.
He has not given any endorsement that he had read over and explained it to the informant. There is nothing, my lord. He has rather said that he has not done so. and the informant was not there, Ali, to justify the factum of lodging of the FIR. This is what I beg to point out to your lordship, my lord.
Right.
So therefore, the genesis also is, my lord, doubtful so far as the prosecution is concerned.
No, all three have been named in the FIR.
My lord, all three have been named, but the FIR has not been, FIR has been written by PW5.
No, that's true. Who says he has not endorsed?
FIR has been written by PW5, and he has admitted during cross-examination that he has not given any certificate in the FIR, that the contents of the FIR were read over and explained to Govardhan Behera, the informant, who died before he could be examined in court. This is what I beg to point out, my lord, to your lordship.
Yes.
Now, my lord, other witnesses your lordship will find have not thrown any light so far as the prosecution case is concerned.
Yes.
So therefore, my lord, if this evidence of PW2 vis-a-vis, my lord, the evidence of PW4 and IO PW10 is taken into consideration, my humble submission would be, here the chain of circumstances, my lord, has not been established, because at best, my lord, the accused persons leaving from the spot can create a suspicion, doubt they might be the author of the crime. But nothing else has been seized to connect the accused persons to have committed the crime, except this statement of PW2, which, my lord, is doubtful because of the improvements he has done in court, and vis-a-vis the statement of PW4 and IO, who have not supported her part of the statement. My humble submission would be, the prosecution has failed to establish each of the chain beyond reasonable doubt so as to form a complete chain for the purpose of sustaining the conviction. And your lordship will find, despite the fact that the learned trial court has taken note of all these contradictions, but has ignored to say that this is sufficient to sustain a conviction. And my humble submission is, this is where the learned court below has committed both error in law and also in facts. Therefore, the impugned conviction and sentence is not tenable. This is what I beg to point out to your lordship. And I have given a written note, my lord, if it is available on record, otherwise I will file it again for your lordships, because I have pointed out the specific statement.
No, it's there. It's there, sir. It's there.
Deeply obliged. My lord, this is what I beg to submit for your lordship's kind consideration.
May I please, your lordship?
Yes.
Well, at the outset, my lord, I will begin by saying that the incident is of April, in the month of April, and it was a moonlit night, which has been there, which is, it has been mentioned in the FIR, as well as it's there in the body of the judgment also. So identification is not a problem, because they're all villagers known to each other, and there was some motive attributed, but unfortunately the people who had spoken of the motive have turned hostile. But nevertheless, the PW2, who is an eyewitness in the sense, as your lordship rightly pointed out, relevant under Section 6 of the Evidence Act, immediate post-occurrence witness, if you can call, not accepting, but not considering, but accepting for the sake of argument, my lord. As the lordship had put it, they heard the groaning sound, they have opened the door, they have come out, and they have seen them just running away. So they will be treated as immediate post-occurrence witness, if not witness. I'll take a lordship to the deposition of PW2, my lord. She is very clear in a statement. Before that, my lord, PW1 is the mother who, though
she'd gone away to collect mahula.
She also doesn't say anything regarding the motive part. That I'll fairly submit, my lord. She doesn't say anything about the motive part, but she says that she heard that these three persons have murdered his son. PW2, my lord. If your lordship will allow me, I'll just, it's a very short.
Yes.
This is Bimbadhara, is my brother. Bimbadhara died about 2 years, 4 months back. My father, Govardhan Behera, died last year in the month of August. My father gave me in marriage in the month of March 1990, 3 months before the date of, there is some discrepancy in the dates, my lord. Para 2. Yes. I know the accused persons, Harsha Behera, Saurabh Behera, and Prakash Sahu. On the night of occurrence, my brother, Bimbadhara, had slept outside the house, and I had slept near the door, and my father had slept a little away from me, and my mother had gone to collect mahula flower. Hearing some sound from outside of the house, my father and myself woke up from our sleep, and my father tried to inquire about the sound. Thereafter, my father, by opening the door, went near the sleeping place of my brother. Both myself and my father went near the sleeping place of my brother. We could see that accused Horasa and Saurata with Bhujali and accused Prakasa with Thenga assaulted to my brother. We say Bacha to Bhujali. After stabbing by means of Bhujali, they ran towards the canal side. My father shouted, holding the name of the accused person.
Embellishment is that we could see that the accused,
yes,
Prakash and with Tenga assaulted to my brother.
That has been brought out in the contradiction, my lord. That has been confronted to the IO. I'll also read the cross-examination, my lord.
Yes.
My father shouted, holding the name of the accused persons, Prakasa, Sarat and Harsa are going away after stabbing Bimbisara. While shouting for help, I went to the house of our neighbors to call them to the place of occurrence. Our neighbors, Achuta and Bipin, they have not been examined, my lord, came to our house. My brother Bimbidhara died instantaneously after the stabbings. As my brother was appointed as the control dealer of our village and he was ordered to lift the stock of the next day, out of that grudge for the said dealership, these accused persons killed my brother. Coming to the cross-examination part, my lord, it is true that she states it is not a fact that I did not state to the IO that accused Harsha and Sarata holding Bhujali and Prakasa holding Thenga assaulted to my brother to death, and that after killing my brother, they fled away towards the canal side. It is not a fact that I did not state to the IO.
So this is the other thing. So when the IO is cross-examined.
Yes, he denies. So this contradiction has been brought forth. But the second part, my lord, that it is not a fact regarding the grudge of dealership. That has not been confirmed.
Argument is, why should we believe a witness like this? How is she a reliable, trustworthy witness? That's the argument.
My lord, witnesses, conduct of witnesses at your lordship's knows.
No. See, if it's a related witness, she's a related witness. She's the own sister. So the argument is one has to be extra cautious in accepting such an evidence.
Right, ma'am.
There is no independent corroboration by anyone else.
There are some hearsay witnesses who say, but hearsay witnesses will be relevant under section 157 of the Evidence Act, my lord. And also under section 6, because they have immediately heard, after hearing the incident, the shout.
No one saw these three running.
No one saw. Assault part, no one has seen. My lord. There is no eyewitnesses to this effect. That is true.
Right.
But this eyewitness, it seems she has exaggerated a bit, knowing that these persons are the assailant. There has been a bit exaggeration, I can say, on my part, my lord. So it is not that she has not completely seen the occurrence. Maybe she has not seen the assault. But not that she's not complete. It is so
Mr. Mishra says that you can't separate the grain from the chaff.
Well, that is where
if you agree that she exaggerated on the assault, we have to disbelieve her even on her seeing them.
Well, then section 6 of the Relevance Act comes to my rescue, my lord. It's just of the same transaction. Somebody assaulting and just going away holding the weapon.
No. Why should you believe her saying that is the question? Not that whether it's relevant. It's relevant. He says, can you trust a person like this? If that person on oath in a court is able to exaggerate, why should we think that what she said earlier is true? Earlier, she made a statement to the police that she saw these three running away.
Yes.
Today, she has said, no, I saw them even assaulting. He says, okay, you are now agreeing, because the IO virtually agrees that no such statement was made to him.
No, that is.
So it is clear that she is trying to exaggerate. A person who's willing to exaggerate just to get the conviction of three persons, why should you believe her statement when she says she saw them running away?
No, that is right, my lord. Exaggeration in the court, my lord, has been taken with little salt, my lord. It's true, my lord. But my lord, can the occurrence be totally done away with? I mean, the occurrence has happened, a death has happened with two.
No, you need the right persons. See, there's no question. Nobody's denying a murder has taken place. You need to catch hold of the right persons. That's the only anxiety.
So the only substance that counts for that she has seen, if at all it is because she has seen them going away.
See, the only argument could be, since they're named in the FIR, the very first instance, these three names have cropped up.
Yes, my lord. Immediately. That your lordship.
So there is no exaggeration as far as the three names are concerned. Because the father who gave that information is not around.
That is why, my lord, the first instant I said that identification was not a problem. They have seen them in the moonlit night. They have identified the assailants. And they have been rightfully named in the FIR, my lord. So had they not named in the FIR and there was exaggeration or...
But how come they didn't recover even one of the weapons?
Pardon, my lord?
They did not recover any of the weapons. No Bijoli, no Burcha,
Weapon has not
no
been.
Tenga.
Weapon of offences has not been necessary. But my lord, but that cannot be fatal to the prosecution, my lord, when there's an eyewitness.
All right.
To the part of the occurrence at least. And my lord, undisputed, which has not been confronted and brought, that there's no contradiction to that part, my lord. Of PW3, we say that because of a dealership, which was he was supposed to get the dealership the next day. And then last night, he has been done away with by the assailants, my lord. I don't think I have much in this to argue.
All right.
Yes,
Mr. Mishra.
Kind permission, may I just supplement one or two things?
Yes.
They have not said motive only with regard to dealership. They have projected 3 motives. So what I humbly beg to submit, the prosecution was unsure of as to what they should attribute so far the accused persons are concerned. Your Lordship will see PW 6. She has stated that this accused Prakash, and that is at page 57.
Yes.
Had misbehaved with Prabhati 7 years back, and he was cautioned. Now, that is also one of the motive attributed. What I humbly beg to submit, the prosecution in the desperation may be because of their ill feeling, and there has been a suggestion that there is 2 groups, and the witness admits saying that I belong to the other group, accused persons belongs to the other group. So, my lord, the enmity is a double-edged weapon. Where, my lord, the prosecution becomes, evidence becomes little suspicious and doubtful, there it will inure to the benefit of the accused man. That is what I beg to submit. And the prosecution is trying to project different kind of motives, which they have failed. My friend said that, yes, there was a dealership. Your Lordship has seen, there is nothing on record with regard to dealership, Your Lordship. So therefore, maybe there may be a suspicion, yes, they were running away, so they might have murdered. So, but that cannot replace, they must have murdered. And that is what I humbly beg to submit for Your Lordship's kind consideration. Then the other part is, the doctor has said the injuries, my lord. Now, no attribution as to who has done what kind of injury, because one of the person even accepting the prosecution person was holding a thenga. So therefore, if Your Lordship looks at also the evidence of PW11, the doctor, that also doesn't justify any kind of assistance to the prosecution vis-a-vis these accused persons. There may be a homicidal death, there may be a murder, my lord, but the culprits concerned should be, my lord, taken to task and the prosecution should end in conviction. It is not that because somebody is suspected to have committed the murder will be a ground to sustain the conviction. This is what I beg to humbly submit for Your Lordship's kind consideration. And so far as the section 6 part is concerned, in fact, in the other case which I had the privilege of placing before Your Lordship, there also I had cited an authority. Section 6 is not just an empty formality. It is subject to other conditions, my lord, stipulations. It is not that just the prosecution will say, yes, we have failed here, so we pick up this part of it, then sustain a conviction. So I'm conscious of illustration A. But the thing is, that is subject to the fulfillment of other riders. Otherwise, section 6 cannot be held to have, can come to the help of the prosecution for the purpose of sustaining the conviction. This is what I humbly submit for Your Lordship's kind consideration.
All right.
May I answer, my lord, regarding the motive part? That is why motive, because this, regarding the misbehavior of Prakash, that people who have stated, they have turned hostile. So I was not harping on that. I'm talking of the motive that the PW2 has attributed and which has not been confronted, which has not been taken as a contradiction by not been confronted to the
dealership.
That is undisputed.
The dealership.
The dealership part.
No, we have adduced evidence, my lord.
They have adduced
there was no
different evidence
like that. There is a different witness, Your Lordship.
I'm talking of the cross-examination of the PW2. I'm talking of the cross-examination of PW2, but that part is undisputed.
And my motive is never relevant unless it is projected. And once the prosecution projects and fails, there the problem arises.
Motive is not relevant when there's an eyewitness also.
Always be there for the purpose of sustaining a conviction. But I am humbly submitting that once you project a motive, you have to establish it. And if it fail, then the scrutiny will be little stricter. Not, that is what I beg to point out. Nothing beyond that.
All right.
I'm obliged by it.
All right. Orders reserved.
Right.
Obliged by.
Item 11. Item 11, sir.
May I please your lordship?
Yes.
Milord, here the four persons are before your lordship. The four appellants along with their mother, Ichabag, they were charged under section 147, 148, 302 and 149 IPC. Milord, the occurrence took place when the PW1 was cutting paddy from the field of the appellants, and her wife PW2 was carrying the same from the field to the threshing floor. Milord, the Law and Trial Court came to the conclusion that the field from which PW1 was cutting paddy, that is belongs to them. That is page 20 of the paper book, inner page 10 of the judgment. I am reading just 5 to 6 9 towards last. In such premises, it can safely infer that the prosecution have utterly failed to establish that the case land is in possession of PW1 and he has a right to harvest the paddy crop. On the other hand, the defense have proved their possession over the same, and in such premises, PW1 has no manner of right to harvest the paddy crop from the land, and he, by doing so, in presence of PW3 to 6 and another Kalia Sunani, has committed certain act to cause wrongful loss to the accused persons and wrongful gain to him. At such premises, the accused persons have right to resist the overact of the prosecution party, and accordingly they indulged in aforesaid incident on the alleged day. Next is important, but particularly the defense pleads otherwise. They have stated that they have not committed any overact, but it is the prosecution party themselves who indulged in free fight after taking liquor in the field and occurrence took place. So far as private defense is concerned, it is, though the appellants have not taken that stand during the trial, but that is also available in the appeal also. The Honorable Supreme Court in Darshan Singh versus State of Punjab has, in that judgment, it has been classified that it is well settled that even if the accused does not plead self-defense, it is open to consider such plea if the same arises from material and record. Here, material and record prove that from our field, the PW1 is cutting paddy. The second, in private defense, the force used by accused ought not to be wholly disproportionate or much greater than the necessary for protection of person or property. Here, for protection of our property,
the right of self-defense.
Yes, yes. Now that defense, I am taking that plea. The appellants have overacted for protection of their property.
How many injuries, sir, and the disease? That will tell us whether they exceed the right of self-defense or not.
And another thing.
What are the injuries and the disease? Tell us.
I'm going to that. So far as the another accused person, Ichabag, is concerned, the Law and Trial Court has acquitted her, and the government has not preferred any appeal, and in the meantime, she died. So far as the injuries are concerned, the trial court has stated that there are 4 eyewitnesses. But so far, eyewitness only trial court said 2 to 6. But the presence of 2 has been disbelieved by the PW 4 and 5, stating that she was not at the threshing floor. And so far as the 3 and 4 are concerned, they stated that when they have the accused give it.
So you read it or you summarize? Either or, because again, if you're going to read after all this, again, you'll be saying the same thing.
Well, I am come to para 87. So far as the non-presence of the PW2 is concerned. His wife means PW2, page 88.
Yes.
Page 88 second paragraph towards last, his wife was near the place of cutting and was carrying paddy. PW1 was looking at us where we arrived and the threshing floors. The entire occurrence was visible to PW1 from paddy field. So here the presence of PW1, PW2, PW1 stated he has not seen the occurrence. So for PW2 is concerned, this evidence is that she was not present. Again at paragraph 97, the PW5 has also stated, page 97, second para, towards last. At the time of occurrence, PW2 was carrying paddy in the field and was not in the threshing floor. I cannot say who was not threshing floor. So here the presence of PWC is disbelieved. Then we'll come so far as PW4 and 5 is concerned. Kindly come to page 93.
Yes.
Page 93, paragraph number 4. Towards last, I have not seen the assault on other persons. Because first she was assaulted, then she stated that she has not seen assault other person. Other person means including the deceased. By accused persons, I was brought to hospital from the village. Then on to page 96. Page 96, paragraph number 3.
Yes.
After reaching the place of occurrence, after receiving blow, last sentence.
Yes, yes.
After receiving blow, I immediately fell down on the ground unconscious. Therefore, first blow was given to him, so he had not seen the accused Kunja. Kunja is the deceased Kunja. So the PW 2, 3, 4, 5, they are not the eyewitness so far as assault on Kunja is concerned. Then only the witnesses are PW3 and PW6.
Yes.
PW3 and PW6, their statements contradicts to each other. And very interesting case is, my lord, while taking accused statement on a 313, the Lorraine trial court has not questioned about the MOs and the MOs. Just I point out, only though there are 4 persons, the witnesses stated that they are holding individual weapons, but only 2 weapons have been MO marked. Kindly come page 33, only MO1, MO2.
Yes.
Page 33, kindly see. Other weapons are not MO marked. So far as one Tobali and Tangi, kindly I am taking your lordship to the accused statement.
Starts at page 42, sir.
Yes. Here is the Vidyathar Bag. Kindly come page 43.
Right.
The question number 8. Then he fell down. He means Kunja. Then he fell down. Then he fell down on the ground, and at that time, Kunja was about to run away, but he was surrounded by you all, and you all dealt blows by means of Tangi, Tobali, Lathi on body of Kunja, and so he fell down on the ground. Not specifically stated this accused which weapon he was holding. Similarly, so far now so far Kalia Bag is concerned, Kalia Bag, the evidence is Kalia Bag assaulted to Kunja by means of Tobali. This is here is also Kalia Bag, page 56. The statement of the accused statement of Kalia Bag came to PW7, 57, page 57. Only same, the evidence is Kalia Bag gave a blow by Tobali to the deceased Kunja. But here also, paragraph 8, question number 8, then he fell down on ground, and at that time, Kunja was about to run away, but he was surrounded by you all, and you all dealt blows by means of tangi, tabali, lathi on the body of Kunja. Not a specific question about assault by Kunja holding tabali. And this particular question was asked and not specifically explained to them which accused are holding what weapon and assaulted with them.
Yes.
So this is a great contradiction. Lord, I will read this decision, just I'm showing this only one. So far as 313 is concerned, the Honorable Supreme Court, in case of Moheshwar Tiga versus State of Jharkhand, it is well settled that circumstance not put to an accused under section 313 CRPC cannot be used against him and must be excluded from consideration. In a criminal trial, the importance of questions put to the accused are basic to the principles of natural justice, as it provides him the opportunity not only to furnish defense but also explain the incriminating circumstances against him. So my humble submission is that since the particular, so far as weapon is concerned, not individually asked to the accused persons, which accused were assaulted by which weapon, that is, they couldn't give or answer. Another thing is that the MOs, the other articles, that is Thenga, Borchi, Arwanbo, and Tangia and Tangi. Miller, the PW7 has stated that he is the seizure witness at page 106, that weapons are not present in the court. Para 4, page 106, paragraph 4 of PW7. On the date of occurrence, police came to our village at about 10 p.m. The weapons often stated earlier were seized by the police 1 or 2 hours after their arrival. Gopinath Majhi and myself were present at the time of seizure of weapon by Exhibit 7. On the date of occurrence, the weapons were recovered in our village. I saw for the first time and I saw those items today in court for second time. It will not be possible to identify the seized tangi if that is fixed with another tangia. The seized lathi and borchi are not there today in the court. The said tangi is also not there in the court. So this is also fatal to the prosecution case. The Honorable Supreme Court I will file the decisions, has held that if the weapons involved in the incident were not seized and MO marked, that is fatal, the conviction cannot.
There are case law on both sides, sir. On that, there are case law on both sides.
But here the incrementing materials are not recovered and MO marked. Another thing I forget to point out, so far as the Kaliabag is concerned, the police says he gave recovery of the weapon after recording of statement under section 27. In the statement of the IO, he has stated that the weapon was recovered from a water reservoir, Tangaraduda water reservoir. That is at page 120. Page 120. Towards last, accused Kaliabag, while in custody, confessed of disposed weapon offense, that is Tobali, concealed, seal, paddy field of Rupsing Sunani. And then towards last, I proceeded village, recorded the statement of Kalia. Witnesses in his statement, accused stated that he have concealed weapon of offense, that is the Tobali, the Tenga, paddy field of Rupsing Sunani, after committing the offense. I recorded this statement. The statement possess of the witnesses before led to give delivery of the weapon. This is the statement of the Kaliabag. The accused Kalia led me to witnesses to the place of concealment and pointed out the place Tangara Doda in paddy field of Rup Singh Sunani. The accused brought the Tobali from the inside of the water and produced me. So far as 313 statement is concerned, the said Kalia was not put the question about the recovery of the weapon from the water reservoir. Only said that was recovered from the paddy field. So this question was not put to him. And another thing, the eyewitnesses PW3 to PW3 to 6, they have stated that they have not said so many things to the police. The police IO PW12 13, he has also admitted that they have not stated so to him. That is at page 123. I am reading. I have examined Rup Singh Sunani PW6. That is before. I have paragraph 9, begin 12, paragraph 9. I have examined Gajani Sunani. He has not stated before me that he requested the ward member Rup Singh to be present at the paddy field. I have examined Mukhi Sunani. She has not stated before me specifically the accused Nakula had a axe, Kalia had a Tobali, Vidya had a lathi, and accused Icha had a lathi with spear. But she has stated before me that such a thing. Then he stated that I examined PW10. No. PW10, he has not stated before me that Rup Singh called me to go to the place of occurrence. He has not stated before me that accused person carried a weapon of offense in gunny bag to place of occurrence. He has not stated before me that accused occurred aimed arrow go to him. He has not stated before me that after sustaining injury, Mohana left the place. He has not stated before me that after a Kunja fell down, besides Kalia, Nakula, Akurura, other dealt blows by means of the weapons to Kunja. Kunja is the deceased. He has not stated before me that accused Vidyabag being honored dealt a blow on the deceased Kunja. I have examined PW4. He has not stated before me that accused Nakula, Vidya, Kalia went behind me back and arrow, which they have already held, was left by him and he left towards the village. He had not stated before me that while he was sitting in the house, Ishwara PW3 reached and reported him that Kunja has been severely assaulted by all the 4 accused persons at the spot, and he also requested him to go to the PS, and thereafter he went to PS and PW3 reported the matter orally to the police and it reduced into writing. 13, I have examined Babula Sunani PW5. He has not stated before me that accused Vidya dealt a lathi blow.
It's all right. You don't have to read line by line like this. Basically, he has said they did not tell him during investigation what they said in court. All right.
And the accused persons are also stated that they have not stated.
All right.
So this proves that their statements have been advanced from time to time.
All right. That's it.
Something more. Millard, the accused persons are 4 persons. They have went to the on that day to their field to protect the property. They have no, and the Kunja Sunani, the PW 3 to 7, along with Kalia Bag, also they are very much present. Kalia Bag also a seizure witness, but he has not examined by the police. They have no motive to kill Kunja. And since they are going there for protection of their property, and in the meantime, they have served 10 years of sentence. And there are no motive. Their case may be considered for section 304 that they have no intention to.
All right. Let's hear the common counsel.
plus PW 8 is the doctor who has conducted autopsy. You'll also get it from page 108 of the paper book.
Yes.
There are at least 7 incised wounds and 2 bruises. Opinion of the doctor is the cause of death was due to hemorrhage and shock, injury to the vital organs like lungs, and time since death was within 6 hours at the time of my PM examination. All the injuries are antimony nature and can result in death. So it cannot be a case under section 304 part 1 or part 2. And there are eyewitnesses account plus there are 4 eyewitnesses. PW2, PW3, PW5 and PW6. PW2 plus I am very categorically implicated the present accused persons. I am reading the first paragraph. I am the wife of PW1 and I know all the accused persons standing in the dock. The occurrence took place on 11th September 1997 at about 8 a.m. On the date of occurrence, I had been to my paddy field along with PW1 to cut paddy, and other witnesses were there. Gentlemen to whom we had requested to go there were some names like Rup Singh Sunani, Mohan Sunani, Kunja Sunani, Ishwar Saltar, Kalia Sunani and Bahadur Sunani. All the said persons were sitting on the thrashing floor adjacent to the Kaliabag land. At that time, my husband, PW1, was cutting paddy and I was carrying the same to the thrashing floor. At that time, accused Akrura Bag, Nokula Bag, Vidya Bag, Kaliabag, both of the appellants was here. And Ichabag came running to the spot. Akrura had an arrow and bow and accused Nokula had an axe. Kalia was having a tabli with him and accused Vidya had a lathi and accused Icha had also held a lathi with a spear. They came running to the spot and reached at the thrashing floor. Accused Akrura was threatening to use his arrow and bow, to whom Mohan Sunani, his PW4, Mohan Sunani, reacted and caught hold of the said arrow. Mohan Sunani caught hold of the said arrow by his hand. Then accused Kaliabag dealt a blow on Mohan by his tabli on his back. At that time, Kunja wanted to pacify the matter. Accused Vidyabag dealt a blow by the lathi on his head. As a result of such blow, Kunja Sunani fell down on the ground. Then accused Kalia, Vidya, Nakul and other accused persons dealt blows to Kunja Sunani by their weapons. Since because I shouted on seeing the assault, accused Icha dealt a blow by means of a lathi fitted with barchi on my left side over the ear. As a result, there was bleeding injury on my head and I fell on the ground and I was carried to my village along with other injured persons and from there to the Patnagar hospital for treatment. I was treated by the doctor at Patnagar. As a result of the assault on me, I had bleeding injuries and my wearing sari was stained with blood, which I have given to the police and seized by the police. Then was a relevant person. You also will find, if I'll may permit to read the whole statement.
Not necessary.
Then was nothing substantial has come up in the across you will also find. And regarding the other and then 3 is also an eyewitness. In the similar fashion, also 3 has implicated both the accused persons, and 4 the persons who have become injured. He was he left the place and went to his house, and subsequently he learned about the assault on the deceased. And 5 and 6, people 5 is also an injured eyewitness. People 5 has also categorically stated that the accused Kalia dealt a blow, plus you'll also get it as page 95 of the paper book.
Yes.
Last 4 lines I'm reading close. Vidya dealt a lathi blow on Mohan on his backside of neck. Because Mohan left the spot after getting hit because he has been examined in Period 4. Then accused Kalia dealt a blow on the back of Mohan by means of a tabli. Having received injuries, Mohan fled away from the spot to the village. Then next paragraph 2, the accused Akrura gave a stabbing on my right arm. Then accused Vidya dealt a blow on my right leg by means of a lathi and also dealt another blow by lathi on my left hand. Then I fell down on the ground. At that time, Kunjo was about to run away, but he was surrounded by the accused persons. Kunjo is the deceased blows. And all accused persons dealt blows by means of tangi, tabli, and lathi on the body of Kunjo, and he fell down on the ground. Kunjo sustained severe bleeding injuries on his person and lost his senses. The witness appears to be a rustic one. The accused Icha dealt a blow, lathi blow on the head of PW2 and she fell down on the ground. Then myself, PW2 and Kunjo were brought to our village by PW1 and witness Kalia. Thereafter, we were shifted to the hospital for medical examination. And in a similar fashion, also PW6 has stated, he happens to be one eyewitness. And also get as page 100.
Yes.
I'm reading the relevant portions plus only.
Yes.
From the top line, at that time, all the accused persons came running to the spot armed with tangi, tabli. Accused Akrura immediately aimed his arrows towards Mohan. Accused Kalia then dealt a blow by means of tabli on the back of Mohan. Then Mohan somehow fled away from the spot. Ishwar also went away from the spot. At that time, Kunja Sunani, the deceased plus, was to my left side. Both of us were trying to pacify the accused persons. Accused Vidya, one of the appellant plus, dealt a blow on the left hand shoulder of Kunja by a lathi, who fell down on the ground. Thereafter, accused Kalia plus the other appellant dealt a blow, tabli blow, on the back of injured Kunja. Then all the male accused persons went on assaulting Kunja by means of their weapons while Kunja was lying on the ground. Even though I objected, none of them obeyed me. By seeing the blood on the body of Kunja, I became nervous. At the same time, accused Icha also dealt. Well, that is not that much relevant. And here, so far as this witness is concerned, he has stated in his cross velocity at paragraph 5, page 102.
Yes.
It is not a fact that fathers of witnesses, Pidul 1 to 6, except Pidul 1 and Saltar are brothers. It is not a fact that we observe obscures if any of the opposite person dies. As soon as we reached at the spot, and sometimes thereafter, the occurrence took place. 10 to 20 minutes after our arrival at the spot, the occurrence took place. All accused persons were coming to the spot by running. Each of the accused were carrying one weapon while coming to the spot. The accused Icha was carrying a gunny bag on her head. I can't say if Mohan had seen this fact at the spot or not. One accused was holding tabli, another accused was holding tangi, the third one is carrying bow and arrow, and accused Vidya was having a lathi. They were not holding the opposite weapons from the beginning to the end. I have seen the entire incident. After Mohan Bahadur was assaulted, then Kunja and then Mukhi, Mohan was not assaulted by anybody except accused Kalia. It is not a fact that I didn't state to the police that accused Akrur and Icha have dealt blows on the deceased. And accused Vidya dealt blow, only one blow by his lathi, because he has denied. And immediately the injured was shifted to the hospital where doctor was in examination period 9 loss. You lost it is at page 111. So immediate treatment has been given by PW11. You'll also kindly see the nature of injuries. One clean cut bleeding in inside wound.
Yes.
Then 2 is one clean cut inside wound. And it is on lateral aspect of left arm. The first one is over scapular region. And third one is one lacerated wound. Fourth one is on inside wound above the eyebrow. And fifth one is next page 112. That is one inside wound at the parietal area of scalp. And then one inside wound over the frontal area of scalp. And bruise. And then one inside wound on the parietal area. All on the vital parts of the organ, of the body. And PW8, the doctor who has conducted postmortem examination also has corroborated to the testimony of PW9. And regarding the 313 statement, my humble submission for Lordship, that is as has been raised by my learned friend, question number 8.
Yes.
There is no wrong in the question number 8 plus. It is at page 43. Then he fell down on the ground, and at that time, Kunja was about to run away. But he was surrounded by a wall, and he all dead blows by means of tangi, tabli, and lathi on the body of Kunja, and so he fell down on the ground. Possible, this can be the question put by the London trial court to the accused. And he has stated that he has this is false. At last, for last question has been put as question of 36 to page 48. Ghatana Sthala Amar Paitru Sampati, I mean, spot of occurrence is our paternal land, paternal property. Prosecution party, plus I'm just translating it. Sedina Modakai Setare Jamalakari Amuku Michare case revocation. The prosecution party have quarreled falsely, and they have falsely implicated us in the case. This much. And regarding the right of private defense, that is not there. And that has been duly discarded by the London trial court. And section, putting a question under section 313, the appellant has to show in what way he has been prejudiced. And it has been, and whether there is a failure of occasional justice. These two things has to be, my London senior has to address the court. In what way he is being prejudiced, and whether there is occasion of failure of justice. And nothing is that, because question number 8 is very clear on that point. It is tabli or tenga or sword, whatever may be the weapons. Yes, formulated question, maybe a composite question by tabli or by tenga. You could have explained it at last, but you have not given any plausible explanation. Rather, only you have said that it is a false case. And you will also find the scientific evidence, that is chemical exams report at page 133. You will also find that has been exhibited at exhibit 30.
Yes.
The tabli that was carrying blood, the parswa was carrying blood, and the lungi, towel, the sample earth, all were carrying blood loss.
Yes.
Well, one part is one page is missing. That's the reason why I cannot see that. I have to verify the LCR. That you can see what C. D is the wearing apparels of the deceased.
Right.
But see what is that? Page 130. That is not visible. Of course, that must be visible. Also,
C is lungi. So C is the lungi.
And of whom, whether it is of deceased or
no, lungi has to be of the deceased only, please.
Yes. So all these accused persons conjointly attacked the deceased is quite clear from the evidence of all eyewitnesses. There are also injured eyewitnesses, P2 and P5, and P4 also in the process has become injured and left the place and went to his house. And P4's evidence also, to the extent that all these persons have gone to the spot of occurrence, and they have assaulted and they have created the entire trouble. That can be also conceived from the evidence of P4. And 2, 3, 5, 6, all are eyewitnesses.
All right.
So far as bloodstain concerned, the serial on Farsa and Tangi, in Farsa, quantity on insufficient, in Tobali deteriorated. At page 13.
Yes.
And so far as the statement, my learned friend was reading this statement of PW7-6. The PW6 in paragraph 100 stated that accused builder dealt a blow on the left hand shoulder of Kunja by his lathi. This other witnesses stated otherwise. They stated that they assaulted on head. So this statement is contradictory to each other. And the medical report is concerned, there was no, the opinion is that 1 and 2 are the injuries which caused the death of the deceased. But the doctor's opinion is that that injuries were by the sharp cutting weapons.
Right.
The only sharp cutting weapons, the only injury which can be caused with lathi, that is the injury number 10. That is only injury number 10, not by others. So for 313, my learned friend answering, If this specifically I was asked about the weapon, which was I was allegedly holding, I could have explained the answer. But here, the principle, since the specific question was
That
not asked,
witness of
the
legal stated.
principle of natural law has been violated, and on that basis, conviction cannot be sustained.
All right.
And plus regarding leading to just one line. PW7 and PW13, they have proved the leading to discovery of the offense.
Or to leading to discovery, one witness was a vital Kaliabag. He was not examined. So non-examination him is also fatal to the prosecution case. And since another thing, since out of 5 accused, 1 accused has been acquitted by the London Trial Court, and the government has not preferred an appeal, the conviction against the appellants are not sustainable.
Convicted under section 302, reduced 34 of the
I pray that I will file a written note with decisions.
Orders reserved. Both parties are permitted to file their respective written notes of arguments within a week.
Within a week. Obliged.
Waiting behind. Ready to argue? Are you ready?
No, I have no case.
All right, got it.
Eighty 83 also. 83.
All right.
The appellants, my lord, challenge the order dated, my lord, 42nd of January 2004, by virtue of which the London Trial Court convicted the appellants for imprisonment of life for life, your lordship. But in this case, the London Court below relied upon the statement, my deposition, the statement of the witnesses. My lord, in para 8, your lordship, London Court below has, my lord, relied the evidence adduced by the PW 1, 2, 3, 10, and 11 found to be helpful to the case of the, my lord, prosecution. And my lord, are no way found to be helpful to the case of prosecution. And my lord, PW number 7, 9, 12, 13, 14, 15, and 16 are found to be the material witnesses in this case. And my lordship, PW 9 and 13 are the medical officers, and 15, 16 are the police officers. And the London Court below relied only the statement of the PW number 5, 7, and 14 for only to, my lord, for conviction of this case, my lord.
Yes.
My lord, the PW 14 is the informant, injured informant in this case, as well as the eyewitness.
Right.
And the PW 7, my lord, here, my lord, the dying declaration was made before PW 7 as per the, my lord, judgment, my lord.
Yes.
And my lord, PW 5 is the relative, my lord, brother of the, my lord, deceased, my lord. PW 5.
Yes.
Only basing upon these 3, my lord, prosecution witnesses, the London Court below, my lord, convict, pass order for conviction of the appellants, my lord. But PW 4, which has been examined in the, my lord, before the court below, he has stated he was the, my lord, scriber of the affair. And he has stated page 68 of the, my lord, is the copy of deposition 68, page 68.
Yes.
He stated that he has scribed the affair, and in cross-examination by defense, he stated that he scribed the affair at Exhibit 6 as dictated by the police at the outpost. And the informant was not present there. and nobody, Gramaraki also not present there. But he was scribed the affair as per dictated by the police, my lord. But he has not been taken care of by the my lord learned court below, while passing the judgment, my lord. And also PW 57 and PW 14 informant, my lord, the statements made by these three witnesses, my lord, is inconsistent statement with each other, my lord. Nobody has, and also they have not corroborated with the prosecution case, my lord. Both of three witnesses are, my lord, inconsistent with each other, my lord. My lord, PW 5, as stated, my lord, before the honor court below, may permitted to, my lord, read the statement, your lordship. PW 5, my lord. I know all the accused person. Deceased Keshav is my brother. Injured Bholanath is my nephew. My lord, the deceased Keshav Nayak is the deceased, and Bholanath is an informant, injured informant of son of the deceased, my lord. He is the informant, my lord, PW 14, my lord.
Yeah.
Deceased Keshav is my brother, injured Bholanath is my nephew. Keshav died since 2 years back. I have heard at my house that my brother had already been assaulted to death. He has heard, my lord. And by hearing this, I came to the spot. I found my brother was lying injured on the village road in front of the house of PW1. PW1 who has been already turned hostile, man. He has not stated anything before the learned court below. Thereafter, Draupadi, my sister-in-law, told that the accused persons, being my nephews, had caused such injuries by assaulting to my brother deceased. Thereafter, the Bholanath, the son of the deceased, also sustained injury by receiving assault. We took the injured brother in a vehicle to Karanji Hospital. Brother here, my lord, the deceased. He stated we took the injured brother in a vehicle to Karanji Hospital. He died at the hospital. Police made an inquest over the dead body of my brother. He had the injuries on head, leg, and hands. Exhibit 7 is the inquest report. Exhibit 7.1 is the signature. The deceased had certain dispute with the accused person prior to occurrence. In cross-examination, he has stated the police has not read over and explained the contents of Exhibit 7. I cannot say about the contents of Exhibit 7. My brother was already shifted to hospital by the time I reached the spot. All were present at the spot. I have not inquired anything from my sister-in-law at that time. She had not stated to me anything. My lord, sister-in-law is the wife of the deceased, my lord. She has not stated to anything. She has not stated to me anything. Bhola was not there at the spot. Bhola is the son of the deceased and PW 14, your lordship. Other persons were present there. Draupadi never told anything to me. Others took my brother to the hospital. Hospital. I have not met Bholanath on that day. Well, he has not met with the informant on that day. My brother was already dead when I reached Karanjia. I cannot say who assaulted my brother. I cannot say when the accused had the quarrel with the accused persons. It is not a fact that my brother had no dispute with the accused person. My lord, he is the my lord, PW prosecution witness number 5, my lord. Thereafter, my lord, prosecution witness number 7, before whom 83.
23. Yes, I am holding different file. Item 23.
Oh,
83.
I am getting.
You have 83 or not?
Yeah, I am getting.
Right.
That file must be here.
My lord, prosecution witness number 7, before whom the deceased has, my lord, stated before his death, my lord, the dying declaration. May permitted to, my lord, place your lordship. I know all the accused person. Injured Bholanath is my friend. Bholanath is the informant. Deceased Keshav is the father of the Bholanath. This occurrence took place 2 years back. Bholanath came running to our house and he had the injuries in his head, in the hand and in the elbow. He reached our house at about 8 a.m. and told that the accused persons had already assaulted his father. He told me that he was also assaulted when he tried to separate his father from the accused persons in the course of a tussle. I brought Bholanatha to Singada outpost. Then we went with a vehicle to bring the injured Kesava. My lord, this is very important. Myself and Bholanatha brought injured Kesava, that is the deceased. Yes, myself and Bholanatha brought injured Kesava in the jeep to Karanjia Hospital. Both are, my lord, with a vehicle taken away the deceased, injured deceased to the hospital. Informant and PW7. Injured Kesava disclosed before me in the vehicle and also at the hospital that accused persons had already caused such injuries on his persons by assaulting. Kesava told me that before the occurrence, the son of Sridhar was playing, son of Sridhar, one of the appellant, was playing without going for study and Kesava had already objected to it. So the accused persons, by bearing grudge, assaulted him. Kesava died at the hospital at night. I have also stated this fact before IO. Police came and held an inquest over the dead body. Exhibit 7 is the inquest report and 7/2 is my signature. In cross-examination, my lord, in cross-examination, you have stated, my lord, I am a literate man. My village is at a distance of 4 kilometers from Sunapasi. He is to cross Patrasaya and Sajansons. Yes, my lord. My father is within, my house is within the locality. My parents and all other family members were in the house. Some villagers also available there. Bholanatha told me that his father had already been beaten and he was lying. So I came with him to outpost. I have not inquired any further from Bholanatha. Yes, I have not inquired any further from Bholanatha. We came in a scooter to the outpost. We reached the outpost within 9:30 a.m. The outpost in charge was also there. Bholanatha disclosed the fact at the outpost police. At the outpost, police reduced his version into writing. Bholanatha also signed there. The outpost in charge went to Roruam police station. After departure of the police from the outpost, we arranged the vehicle to bring Kesava. I found Kesava was lying on the veranda of a house of Dhanu. Well, Dhanu is the prosecution witness number 1 who has been turned hostile. Kesava was able to talk by that time and water also supplied to him while he was lying on the veranda of prosecution witness number 1. It is not a fact that I have not stated. It is true that I have not stated to the IO that it is true that I have not stated to the IO that the son of Sridhar was playing without going for study and received objected to it. And the accused persons having grudge assaulted him. We reached Karanjia hospital at about 12 noon. Kesava has also stated this fact before the doctor. Kesava also, my lord, here this is very important. My lord, we reached Karanjia hospital at about 12 noon. Kesava has also stated this fact before the doctor. The doctor also wrote the same in a piece of paper. My lord, the dying declaration. Police has reached the hospital by that time. I have not seen any of the accused persons by going to their village. It is not a fact that Bholanatha never come to our house and I only visited the hospital after hearing the death of Kesava. It is not a fact. I have signed in a piece of paper at the hospital. I signed at the hospital when police arrived there. Now, prior to death of Kesava, I signed at the hospital when police arrived there and prior to the death of Kesava. My lord, now, my lord, I want to drag your lordship's kind attention as a statement of prosecution witness number 14, that is the eyewitness as well as the informant, my lord. Well, here, my lord. Yes. Here, my lord, he has stated, here PW7 stated that he went to the house of the my lord PW7 before whom the dying declaration is made. But the informant eyewitness stated that he has not stated anything to the informant. Sorry, my lord, prosecution of witness number 7. He has not stated anything, and also the informant and his my lord deceased father was taken away by the police in their jeep. The PW7 was not there.
Yes.
My lord, may I permitted to read, my lord. I know all these accused persons. Deceased Keshav Naik is my father. This occurrence took place 4 years back. At about 7 a.m., I was found sleeping inside the house, and at that time, accused Lakshmidhara and Sridhara came to our house and called my father to the outside. Well, accused Lakshmidhara and Sridhara came to our house and called my father to the outside. They took my father by holding to the outside. All these are 4 accused persons assaulted to my father at a distance of 20 cubits from our house. Such assault took place on village Danda, my lord, and it was broad daylight at 7 a.m., my lord. Village Danda, my lord. Sridhar Naik was found holding an iron rod. Lakshmidhara Naik was found holding a piece of wood. Harikrishna Naik was holding X, and accused Rosananda was found holding a bamboo lathi fitted with a sickle. Is that bamboo lathi? And all these, my lord, the weapons are marked as exhibits, etc. Yes, well, thereafter, my father started shouting. All are holding the offensive weapons, my lord, and it was, my lord, fitted with the MOs. But here, nothing mentioned that they have assaulted, my lord. But direct, my lord, I may permitted to again read, my lord. Village Danda, Sridhar Naik was found holding iron rod. Lakshmidhar Naik was found holding a piece of wood. Harikrishna Naik was holding X, and accused Rosananda was found holding a bamboo stick fitted with a sickle. MOIV is that bamboo stick, a bamboo lathi with sickle. MO triple I is the piece of wood. MOII is the X, and MOI is the iron rod. My father started shouting. I went nearer to my father to rescue him. When I tried to separate them, the accused persons also assaulted me. All the 4 accused persons assaulted me. He sustained bleeding injury throughout his body. The bleeding injuries were found all over his body. I also sustained injuries.
So why don't you comment on the witness? You're going on reading. You have to, if you argue, you should not go on reading, sir. You should comment on the witness.
Yes, sir. Yes, sir.
Why should this witness be disbelieved?
My lord, yes, sir. My lord, para 2, my lord, of examination in chief. I verbally reported the matter at the outpost, and police reduced my version into writing. Police went to the, my lord, here, this is very important. Police went to the spot and brought my father in a jeep. My lord, myself and my father was taken to Karanjia hospital by the police in a jeep. But my lord, there, my lord, the PW7, he has stated that he taken away the deceased to the hospital, my lord.
Right.
And in the jeep, he stated before, my lord, before the PW7 regarding his assault, my lord.
All right.
But yes, but the eyewitness stating this thing, my lord. Thereafter, my lord, on the same day he expired. Father was treated at the hospital, but on the same day he expired at the hospital. I remained at the hospital for 1 hour for treatment. Police examined me and I was stated, my lord. And in cross-examination, my lord, the eyewitness, my lord, the informant, stated that I cannot say, my lord, although he is an eyewitness, he stated, my lord, in the cross-examination at page 93, my lord, middle portion, I cannot say which point, I cannot say, pointing out the place to which each accused assaulted I have not counted the number of strokes during assault. I have mother, wife, and other brother. Mother also arrived there and she saw the occurrence, but he has not been examined by the police. He saw the occurrence. My mother also seen out, she was not assaulted. The accused persons assaulted us for about 1 hour. Hare Krishna assaulted. And my lord, here this is very important. Para 4, my lord. Cross examination. Para 4. We had the land dispute prior to 3 years of this occurrence. We had the good relationship prior to this incident, my lord. My lord, they have a good relationship. All the weapons were also, and also stated that all the weapons were also stained with blood, but there is no such report, my lord, to my lord establish whether the blood, my lord, stained with the weapon of offense belongs to the deceased or not, my lord. And my lord, the last, my father also, this is very important, my lord. The deceased, my lord, the informant stating that my father also gave the statement at the hospital before police and also doctor. And police and doctor recorded the statement of my father. And that has not been in the record, my lord. But the learned court below, my lord, without taking care of, my lord, taking into account the, my lord, this statement, as my lord stating that all the witnesses are corroborated with each other. I never went to the spot. I never, my lord, this is also important. I never went to the spot in the jeep with police. While returning from village, police brought me and my father in that jeep to the hospital. Police never brought the weapons in that jeep. Police never asked me. Police never asked me in this case. I never stated anything about this occurrence to anybody. He has not stated anything to anybody. But the PW7, my lord, before whom the dying declaration was made as per prosecution case, he has stated that the informant went to his house and told that the accused person already assaulted his father, my lord. That is, my lord, all are, my lord, so false, my lord. He has not stated anything, my lord. And my lord, the learned court below, basing upon, my lord, this statement of these 3 prosecution witnesses, my lord, has come to the conclusion and sentenced the appellants to, my lord, for imprisonment for life, my lord, which is, my lord, not, my lord, believable. And all these witnesses, my statement of these witnesses are not reliable and trustworthy, my lord. And that about, my lord, the prosecution, my lord, hereby, my lord, grossly failed to establish his case beyond all reason.
Yes, Mr. Katkia. 3 eyewitnesses.
PW 14 happens to be the eyewitness, injured eyewitness.
Keshav.
Pardon me?
Keshav. Bholanath.
Yes, yes.
Keshav is it?
Yes.
Right.
Keshav.
Disease is Keshav. Correct. Bholanath is correct.
Keshav disease. Plus, at page 91
yes.
of the paper book, you'll also get the deposition.
Yes.
Plus, I'm reading the last 4 lines. Sridhar Naik is appellant number 2, was found holding an iron rod. Lakshmandar Naik was found holding, Lakshmandar Naik is appellant number 4, was found holding a piece of wood. Hare Krishna Naik, he happens to appellant number 1, was holding an axe. And accused Rasanand is appellant number 3, was found holding a bamboo lathi fitted with a sickle. MO4 is the bamboo lathi with sickle, MO3 is the piece of wood, MO2 is the axe, and MO1 is the iron rod. My father started shouting. I went nearer to my father to rescue him. When I tried to separate them, the accused persons also assaulted me. All the 4 accused persons assaulted me. He sustained bleeding injury throughout his body. The bleeding injuries were found all over his body. I also sustained injuries on my forehead and hands. I lost sense and accused persons fled away from the spot. When I regained sense, I went to a blind man known as Chintamani Naik and got some wearing clothes from him. I also went to the house of Dhyana Behra, PW7. My friend. They gave me milk and I was taken in a scooter to Singda outpost. I verbally reported the matter at the outpost and police reduced my version into writing. My signature. Police went to the spot and brought my father in a jeep. Myself and my father was taken to Karanji hospital. My father was treated at the hospital, but on the same day he expired about 4 to 5 p.m. I remained at the hospital for 1 month to get treatment. Police examined me and have stated all these facts before police. The accused persons are the relatives of my father, being his brother's son. We had dispute for landed properties. This is important clause. And plus, next page, I am page 93. I am going to the middle portion. I came to my father.
Yes.
I came to my father. Yes, during his cross-examination, that witness has stated. I came to my father by hearing his shoutings. So when I reached the spot, I found my father was lying. All the 4 accused persons were found assaulting my father. When he was lying on the ground, they all assaulted to my father, and I can say, pointing out the place to which his accused assaulted. I have not counted the number of strokes during assault. I have mother, wife, and other brother and mothers. These are all irrelevant. And in paragraph 4, page 94, again, regarding the motive, we had the land dispute prior to 3 years of this occurrence. We had the good relationship prior to this incident. There was a quarrel between my father and the accused persons for the cause of a child. They had no such altercation with me. There were patches of blood found at the spot. All the weapons were also stained with blood. Plus, nothing substantial has come up to help the defense.
Yes.
I am taking your lordship to PW7.
Yes.
At page 73,
Yes.
Dhanachandra Behra, I know all. I will also got it.
Yes.
I know all the accused persons. Injured Bholanath, PW14, is my friend, Swangata. This is Kesav, is the father of Bholanath. This occurrence took place 2 years back. Bholanath came running to our house and he had the injuries on his head, in the hand and in the elbow. He reached our house at about 8 a.m. and told that the accused person had already assaulted his father. He told me that he was also assaulted when he tried to separate his father from the accused person in the course of a tussle. I brought Bholanath to Singla outpost. Then we went with a vehicle to bring the injured Kesav. Myself and Bholanath brought injured Kesav in the jeep to Karanjia hospital. Injured Kesav disclosed before me in the vehicle and also at the hospital that accused persons had already caused such injuries on his person by assaulting. Kesav told me that before the occurrence, see the reason. Kesav told me that before the occurrence, the son of Sridhar was playing without going for study and Kesav had already objected to it. So because the appellant's son didn't go for tuition or for study, the deceased just objected to it. That is the reason why these persons get aggrieved and assaulted the deceased. And for a moment, you'll also come to page 75. To a question the witness has stated, Kesav was able, second line from the top. Kesav was able to speak, able to talk by that time, and water also supplied to him. And now I am taking lordship to the opinion of the doctor. Plus, first, both the injured and the deceased were taken to Dr. Manoranjan Malik, examined as PW 13 plus. You also get it as page 87.
Yes.
So here from the first paragraph, on 8/4/2000, I was assistant surgeon of Karanjia Hospital. On that day, I admitted Bholanath Naik, PW 14, at 10:30 a.m. at surgery department of Karanjia Hospital. I have examined the patient and advised treatment. I advised him for X-ray of his wound. I have noted down different injuries found on his person at the bedded ticket. Exhibit 19 is the bedded ticket. So the injured has been examined initially by this doctor. Then he has stated again on the same day I have admitted Kesav Naik, the deceased in the same surgery department. When the patient was admitted in the hospital, he was in life. The patient was declared dead at 5 p.m. on the same day. I have mentioned the condition of the patient when I received him first in the hospital. And I have recorded his temperature, blood pressure, etc. According to my opinion, in that condition, the patient was in a fit state of mind and capable of giving a rational answer. This is important, page 88. Then, of course, paragraph 3 has stated, I have not made any effort to record the dying relation and was referred to surgical department. On that day, I was in charge of outdoor. I'll come to the injuries now. The number of injuries, 6 number of injuries. One is an incised wound on the skull, plus right side of skull. Then second one is also an inside wound by a sharp cutting weapon. And third one is also lacerated wound.
The other rest are all lacerated.
All lacerated, all three. The two inside wounds. And you'll also find to the bottom fracture of right humerus, compound fracture on the left tibia and fibula. Inside wound over the left so there is fracture, there is inside wound, and also there are lacerated wounds. And injury number 2 was fatal, plus third line from the bottom. Injury number 2 was fatal to human life. The injury number 4 was also fatal to human life. The patient survived for about 5 hours of my examination. Injury number 2, 3, 4 were also bleeding injuries. It took me hardly an hour to measure the injuries and to tender treatment to both the patients. I could have recorded the inclination within a shorter period by examining the patient, but neither I have done nor I have remembered the surgery department. So overall, this is the evidence of the doctor, both the doctors, doctor who initially admitted in the hospital, Korangi Hospital, and the second one, the PM doctor. And the eyewitness account is being well corroborated by the
medical evidence.
Yes, by the medical evidence. And so also the dying declaration on the question of diagnosis, you also have delivered so many judgments, like Anjali Raut versus State Plus, I will provide all the judgments. And so there is no escape for the accused, for all the appellants. Yes. Rightly, they have been convicted.
Yes, please.
Madam, in this case, all these three witnesses are, my lord, interested witnesses and relatives of the deceased, my lord. My lord, I would like to, my lord.
You give the citations, you don't have to read.
Citations, you know.
You can give the citation.
My lord, thereafter, my lord, I want to, my lord, page 73, my lord, PW7.
Yes.
He has been stated that myself and Bholanath, who is the informant, my lord, brought injured Keshav in the jeep to Korangi Hospital. And injured Keshav disclosed before me. My lord, in a vehicle, both are there. But only PW7 stating that he was stated before me, to which the informant has not been stated in his, my lord, entire statement, my lord. But only, my lord, PW7 has stated. And that apart, my lord, informant, my lord, in the informant eyewitness, he is stating that he and his father, my lord, went to the, my lord, hospital. My lord, went to the hospital in the police jeep, my lord. But he has not stated, my lord, about the PW7. Yes, lord. Police went to the spot and brought my father in a jeep. Brought my father in a jeep. Myself and my father was taken to the Korangi Hospital by the police, my lord. But the PW7 has stated, my lord, my lord, he and my lord, the informant taken the, my lord, deceased to the hospital in a vehicle, my lord. But that is the, my lord, indiscrepancies, my lord, between the statement of PW7, 14, as well as PW5 also. Basing upon these three prosecution witnesses, the learned trial court, my lord, final, my lord, passed.
File your written note about it.
Yes, lord, my lord.
You are applying for 2 and 4 also.
4, my lord. 4, my lord.
No. One appellant is dead.
My lord, although, my lord, all these 4 appellants, my lord, no contact with my lord.
No. You are appearing for all of them.
Yes, your lordship.
All right. Yeah.